that specialist court, a lot of interest has arisen around contemporary issues in employment law jurisprudence. It is my pleasure to introduce, by way of reading a short citation, my Lord, Honorable Justice Kanyip, President of the National Industrial Court. Honorable Justice Kanyip was appointed a judge of the National Industrial Court in 2000 for an initial period of 4 years, although with eligibility for a renewal for a further term of 4 years. In June 2004, having completed the first term, his appointment for another term of 4 years was renewed. And he is now a tenured judge of the court. Honorable Justice Kanyip attended Ahmadu Bello University, Zaria for his LLB, and the Nigerian Law School, Lagos, Nigeria for his BL. After the mandatory 1-year national service, he took up a teaching appointment as a lecturer of the Ahmadu Bello University, Zaria in 1987, and rose to the position of lecturer 2 before leaving in 1992 for the National Commission for Colleges of Education as legal advisor in the rank of principal legal officer. In 1995, he was appointed senior research fellow at the Nigerian Institute of Advanced Legal Studies and rose through this appointment to the rank of associate research professor of law in 2000 when he joined the court. His lordship is the author of numerous scholarly articles in the areas of consumer law, labor law, tax law, and commercial law. He is the author of the book, Consumer Protection in Nigerian Law, Theory and Policy, 2005, and a joint author of the text, Elements of Commercial Law, 1994. Honorable Justice Kanyip has had professional dealings and done consultancies for the Economic Community of West African States, ECOWAS, the International Labour Organization, ILO, as well as the federal government of Nigeria on labor and related areas. He's a member of the International Bar Association, a fellow of the Chartered Institute of Taxation of Nigeria, life member and deputy president to Nigerian Society of International Law. His lordship is a contributing editor of several academic law journals. Honorable Justice Kanyip is widely traveled. Honorable Justice Kanyip is the presiding judge of, I think this one is wrong. He's the president of the National Industrial Court of Nigeria. It is noteworthy that his lordship, Honorable Justice B.B. Kanyip, was the worthy lieutenant of the erstwhile president of the court, Honorable Justice B.A. Adejumo, OFR, retired. Having been appointed on the bench of the NIC since 2000, little wonder thereafter that the processes leading to his lordship's confirmation as substantive president of the court, and on the 13th of December 2009, his lordship, Honorable Justice Kanyip, was sworn in as the president of the NIC. It is my pleasure, therefore, this afternoon to welcome this very distinguished academic and jurist to educate us this afternoon on no less a subject matter than he's the leading light in Nigeria. It is my pleasure to welcome Honorable Justice B.B. Kanyip. Welcome, my lord.
Thank you, Chairman. And participants, panelists, good afternoon and welcome. I hope I'm being heard clearly. Am I being heard?
Yes, my lord, you're being heard. And just a second, I forgot to make the point. My lord has requested specifically that people ask as many questions as possible. He would please prefer this session to be as interactive as possible so that he addresses your questions rather than speaks to you. So I'd urge as many of you as possible who have concerns about issues, any issue at all regarding employment law jurisprudence in Nigeria, to raise those questions in the Q&A box so that once he finishes his presentation, we can start taking those questions. Thank you very much. My lord, Over to you.
Thank you, Chairman. So, I've been asked to talk today, and the theme of discussion is overview of Nigeria employment law and the role of the National Industrial Court in deepening employment law jurisprudence in Nigeria. Of course, the assumption is that a new jurisprudence is being worked out, and because it's new, there are gray areas that are still unfamiliar, and there are areas that let me start by saying the concentration on employment law as against labor law presupposes a concept we may be familiar with. It's a concept that is actually pursued by particularly civil law jurisdictions like France, where a distinction is made between employment law and labor law. Within that context, if you talk of employment law, you are talking of what we term the individualization of rights and the law itself. In other words, the emphasis is on the individual rights as between an employee and an employer. But when you talk about labor law, there's an element of collectivization. In other words, you are looking at the subject matter within the prism of the collective rights that inure to workers in a collective sense and employers also in a collective sense. We are yet, or in Nigeria, we do not really have this distinction. And so the tendency is to use them as alternatives. Some universities, for instance, would teach employment law. Some universities would teach labor law. Now, I happen to be part of the process that gave rise to the National Industrial Court Act 2006 and the third alteration. And so if you pick any of these statutes, there's a tendency for you to see an interchange in the use of the words employment law or labor. I give you a simple example. If you look at Section 7 of the National Industrial Court Act, jurisdiction, for instance, is given to the court in respect of labor, industrial relations, and so on. Employment is not mentioned. So the tendency then was that the National Assembly deliberately left out employment because, following from the jurisdiction of the National Industrial Court in respect of trade disputes, again, don't forget, the definition of trade disputes suggests some kind of collective disputes. If you look at whether the Trade Disputes Act, the Trade Unions Act, or even the National Industrial Court Act itself in terms of the definition. Of course, if you look at the definition of trade disputes under the National Industrial Court Act, you will notice a little variation between it and what you find in the Trade Unions Act and the Principal Act, the Trade Disputes Act. So, within the context of the point I'm trying to make, when Section 7 of the National Industrial Court Act deliberately did not use employment, the tendency was to conclude that the jurisdiction of the National Industrial Court remained only in respect of collective labor disputes. In other words, the individual disputes between employer and employee did not. But of course, I remembered vividly, I think it was in 2007, exactly 1 year after the promulgation of the National Industrial Court, we had court to give judgment in respect of an issue where we even called amicus curiae to come and address us on the question whether labor as used in Section 7 of the National Industrial Court Act included the individual rights. Because at that time, as regards collective labor disputes, the understanding was that so long as they qualified as trade disputes, we did not even have original jurisdiction. What we had was appellate. In other words, you have to exhaust the dispute resolution processes of Part 1 of the Trade Disputes Act before you can come to us in our appellate jurisdiction. And the question now was that in using labor in Section 7, did it include individual disputes between employees and employers? 1 year after the 2006 NIC Act, in a decision, we came to the conclusion as a court that yes, it included. In other words, we interpreted labor liberally to also include employment. But that debate continued. And when the opportunity came in the third alteration, it was felt, because I participated in the public sessions at the National Assembly, that to be able to remove all doubts, it was necessary to give NIC jurisdiction over employment. And that's why you would find the word employment in Section 234C1, in addition to labor that had been there since 2006. But even at this, I remember vividly in Lagos, a matter involving Coca-Cola came on board. And then it was argued by the current Vice President, Professor Yemi Osibajo, SAN. He was counsel to the claimant who was suing against dismissal by Coca-Cola. And learned SAN Candid Johnson was counsel for Coca-Cola. I remembered him vividly raising the question via a preliminary objection, as well as a case-stated request that the constitutional use of the word employment did not include private employment. I did not agree with that position. I held that employment means employment and it includes private and public employment. The matter on on appeal to Court of Appeal from my decision, they agreed with that stance. A further appeal, I think via case stated also to the Supreme Court then also agreed that employment was general and include private employment. In other words, it included master and servants. Now, why am I bringing this history? Sometimes when we talk about employment law, particularly from a global perspective, and taking into account that National Industrial Code has jurisdiction to apply international best practices, the tendency is that not to forget that globally, some jurisdictions understand employment law as the law that relates to the individual rights of the employee relative to the employer, while labor law looks at the collective rights that inure in that regard. In other words, even when we look at it that way, it also yields to a problem. Currently, there is what is being said to be the identity crisis of labor law. In other words, there are boundaries of labor law today that are no longer certain. For instance, we are not too sure today, as we were years back, who an employee is, particularly if you look at modern forms of work where robots are now taking over some work by employees. And the general attitude is to think of an employee as an individual. In other words, we look at an employee as an individual who is a human being. And you will not be wrong, because even within the context of ILO, the decent work agenda, for instance, has as a principle that labor is not a commodity for sale. And why is that so? Because of the fundamental right that we have as individuals, the human dignity right we have, which if translated to the world of work, also dictates that our working conditions must have dignity. In other words, there are certain kinds of things you can't ask an employee to do for the simple fact that it debases his humanity, it debases his dignity. And that is why there is this cliche. We employed workers, but what we got were human beings. In other words, the fact that you employed me as an employee, and when I come to the workplace does not mean I have forgotten or sacrificed my fundamental rights. Even the workplace rules even the workplace principles, even workplace rights can be interpreted within the context of our constitutional fundamental rights. But of course, it raises questions. In one or two occasions, I've had cause to ask the question, what's the best form to protect an employee? Is it by normal law? Of course, we've seen how problematic the common law is, because it's the common law that gave us principles like you can hire and fire at will. So that common law posture does not guarantee useful rights to employees. So if the common law is not too good, it means we can't rely on judgment law to be able to give rights to employees. Can we, for instance, do it through statute, or do we do it through constitution? I have argued that in the main, in some circumstances, and I have given examples in some of the write-ups I did, that the constitutionalization of labor rights comes with its own brand of problems. I remember a federal high court decision where it was held, somebody claiming, I think there was an issue regarding whether a claim in relation to HIV under the discrimination rules could work. And the federal high court held that because HIV was not one of the named items of discrimination in the Constitution, you cannot claim protection under that particular provision. Now, that is possible because there is an attempt to constitutionalize the question of HIV within the named parameters in the Constitution. But of course, nothing was said about the human dignity issue. And consequently, there was that particular problem. So the Federal High Court could do that because in interpreting labor rights within the context of constitutional law, the tendency is to be strict. And a second example is if you take the freedom of association provision, I think under section 40 of the Constitution, you will discover that the rights of formation of association is the same in relation to trade unions as it is with political parties. And I have asked a simple question, and I have seen lawyers fall into that error day in, day out. When arguing about the right to associate for purposes of trade unionism, I have seen lawyers cite cases dealing with the right to association as relates to political parties. And I've asked a simple question. Don't forget, I think it was Lord Stern who said in law, context is everything. I've asked a simple question. The attributes of a political party, are they the same with a trade union? The answer is certainly no. So when you cite a case dealing with a political party's right of association or individuals' right to form political parties, and you transport it to the individual's right to form a trade union, you are bound to get some things wrong because the considerations are certainly not the same. For instance, for us now at the NIC, where we have powers and jurisdiction to apply international best practice in trade unionism is certainly different from international practice in political parties. It will sound odd, for instance, if cases dealing with courts stopping delegates conference in trade unions are associated or equated with the same cases where courts stopped the election of political office holders that would stand election. The point I'm trying to make is that, yes, Section 40 deals with right of association and to form political parties in the same manner as it says about trade unionism. It does not say well for a lawyer, for instance, to come to court and cite cases in relation to political parties in matters that are dealing with trade unions. The two are basically different. And I think in one or two of my judgments, I've had cause to point this, that the cases cited were out of context because they dealt with political parties who have no relationship whatsoever with trade unions. So you would find a number of these issues on ground. Let me come back to the history, so to speak. I've been talking about the NIC Act and so on. If you take a closer look at that law, incidentally, since 2006, I have hardly seen any lawyer, even in court or in writings, that have been able to notice the slight distinctions that are within that act, which were deliberate. Now, the story about the NIC Act, when it was being done in 2006, I was then a member of a technical committee set up by government. There was this project called the Declaration Project. In 1999, when the NIC, when we returned to civil rule, I think the then president of US, Bill Clinton, visited Nigeria. And one of the things he did was to assure Nigeria that they were going to make funds available to help the democratic process. And one way of helping the democratic process was the reform of the labor field. But they said they can only do it through the ILO. So funds were made available, and the ILO, through what was called the Declaration Project 1999, decided to set up the structures to be able to reform, particularly our way of doing things, just so that we can bring them to terms with the democratic dispensation we have at the moment. I need to make a point here. If you look at our labor laws, when I say labor laws, I mean the totality: Trade Unions Act, the Trade Disputes Act, the Labor Act, anything that has to do with labor, you would find that today, except for the 2005 amendment to the Trade Unions Act, the 2006 NIC Act, the 2010 Employees Compensation Act, and the third alteration, every other bit about the labor laws in Nigeria is a product of military rule. In other words, they were products of degrees. So when in 1999, we started this current civilian dispensation, the point was that we were having a labor system that we inherited as a result of our military experience in governance. If you compare us with a place like South Africa, what you have in South Africa was a system where labor, alongside other pressure groups, were in the war front in the fight against apartheid. So you had a labor system that assisted the democratic process. In other words, you had a labor system in South Africa that was able to evolve and give rise to democratic dispensation. In Nigeria, ours was almost like the reverse. We had a labor system that was built or structured within a military system, now being asked to work under a civilian system. The idea was that this thing will not work. So part of the mandate of the the Declaration Project was the review of labor laws. Incidentally, I was contracted by the ILO then to do a comparison in terms of the structure of Nigerian law, labor laws, and find out the extent to which they were in conformity with ILO conventions that Nigeria ratified or that are binding on Nigeria, and the extent to which they were not. So I was able to do this work with Professor Agomo. We did it and submitted the report. And when the technical committee was formed to review all the labor laws, I happened to be one of the two who represented government. We were 6, actually. 2 of us represented government. There were 2 representing employees, and there were 2 representing employers. Within labor, there are usually 3 stakeholders: labor, employee groups, employer groups, and then government. So I was one of 2 people representing government. We were able to review all the labor laws and suggest all of them to be compressed into 4. One was labor institution bills. The idea was that institutions like the IAP, that's the Industrial Arbitration Panel, which we rename as the National Commission for Conciliation and Mediation, National Commission for Conciliation and Mediation, tailored after the CCMA of South Africa. Even the Office of Registrar of Trade Unions were supposed to be like effectively put within one law with powers, particularly of perpetual succession and independence. Then we had the Collective Labor Relations Bill, which was supposed to take account of collective labor rights like trade unionism, the resolution of disputes and all that stuff. And then we also have the Labor Standards Bill, which was supposed to indicate the minimum standards that every workplace must have. And the fourth one was the Occupational Health and Safety Bill. The idea was to bring all the laws applicable in Nigeria within this four structure. Now, within the context of the Collective Labor Relations Bill, the dispute resolution systems were set out. And what we suggested was that as much as possible, all disputes, whether employment or labor, must go through conciliation. Then some will go through arbitration, some will get up to adjudication, which is what the NIC does. And our suggestion was simple. Certain kinds of disputes were not to go beyond arbitration, which means that what was to come to NIC shouldn't be up to more than 15% of the disputes. And even within the context of conciliation and arbitration that we suggested, we also suggested that private arbitration be inbuilt in it. Let me make the point that within the structure of ILO, the current Arbitration and Conciliation Act does not apply because it is principally meant for commercial dealings. We've had one or two cases where we held in the NIC that when it comes to labor disputes, you can't cite the Arbitration and Conciliation Act. Of course, if individuals decide to go and settle their private labor or employment dispute within the structure of the Arbitration and Conciliation Act, and they come to us for enforcement, we are going to take it because we have power to enforce an arbitral award. But if you want to do the arbitration within us, using the Arbitration and Conciliation Act, we would say no, that act does not bind us, and consequently, we cannot use it. So we were able to suggest a reduction of these laws up to 4. We did and presented up to the point where it was even presented at the Federal Executive Council, and it was then remitted to the National Assembly as executive bills. Unfortunately, till today, those bills have not seen the light of day. Now, why am I telling this story? While I was a party to that technical committee, knowing what was being suggested, the 2006 NIC Act was also being worked at the National Assembly. And because I participated at the public hearing, I was able to draw attention to some of the things we were suggesting. Now, at the point of the 2006 NIC Act, what we had on ground were sometimes a misconception of some of the terms that were already terms of act. Take, for instance, the term or the phrase trade dispute. If you go to Section 48 of the Trade Dispute Act, if you go to the Trade Unions Act, or if you even come to the NIC Act, of course, the NIC Act is a later thing. If you take the Trade Unions Act and the Trade Dispute Act, you would find that trade dispute is defined in its corporate, in inverted commas, trade dispute. But it was His Lordship, Justice Nic Act, he was then JCA of blessed memory, who in analyzing what a trade dispute is said, there are requirements for you to prove before you can have a trade dispute. And he said, firstly, there must be a trade. Secondly, there must be a dispute. Now, the moment trade was taken away from dispute, that was the day we got it wrong. Because trade dispute defined by law was defined as trade dispute in its corporate phrase. Nothing was, I like giving this example. Go to the Constitution, you would see the word or the phrase public service of the Federation. And I shudder to think that if it gets to the Supreme Court today, what is public service of the federation. The Supreme Court will say there has to be public first, then service, then federation. I'm not too sure the Supreme Court will go that route. So when Justice Nic Act decided that for there to be trade dispute, there has to be a trade first, then a dispute. From that day, we got it wrong. Until today, if you read particularly some decisions at the Court of Appeal, you are going to find this same thing being repeated. So we felt that if we continue along those lines, first, we now have a distorted view about what a trade dispute is. And because of that, you can't change it until it gets, for instance, to the Supreme Court. And it's unlikely with the current dispensation that it will ever get to the Supreme Court unless you do a case stated under Section 295. So we decided that instead of trade dispute, let us introduce a new concept, which is labor dispute. Or let us introduce another concept, which is organizational dispute. So if you go to Section 7 of the NIC Act, you would see the words labor dispute and organizational dispute. And in the interpretation section, those words are defined. Organization is another term used by ILO for trade union or senior staff or employers association. It's like a generic, instead of talking of trade unions, senior staff associations, employers association, you simply talk about workers organizations or employers organizations. So organization is a fluid general term used by ILO to be able to encompass this. So we decided that if we introduce the word organizational dispute, for instance, we will also be solving a second problem. And what was that second problem? In 1992, because of the conflicts, if you look at the Trade Disputes Act closely, I think it was in 1988 or thereabout that Section 24, which is it's been repealed now, was put in. And Section 24 then talked about NIC hearing appeals from IAP in respect of inter and intra-union disputes and categorized the type that would come. But despite that provision, inter and intra-union disputes kept going to the High Court, kept going to the High Court, kept going to the High Court. So in 1992, to avoid this confusion, a new Section 1A, which is today Section 2 of the TDA, was introduced, where NIC disputes regarding inter and intra-union disputes were now introduced in Part 1 of the TDA, with the statement that no court of law should hear any matter or action relating to inter and intra-union dispute, and all those ones that are pending must abate. Of course, NIC was interpreted as also a court of law, which means in original jurisdiction, neither the High Court nor NIC can take inter and intra-union disputes in their original jurisdiction. They can only come if they go through the processes of Part 1. But as recently as I think 2016 or so, there is a Court of Appeal decision which specifically held that because inter and intra-union disputes were not mentioned in Section 1 of the TDA. If you read Section 1 of the TDA, it talks about, it defines, it says this part shall apply to trade disputes. And the Court of Appeal said, because inter and intra-union dispute was not put there, it means this part does not apply to inter and intra-union dispute. But in 2020, another Court of Appeal decision, this time around, the 2016 was a Court of Appeal decision of the Kaduna Division. But in 2020, the Court of Appeal in Makurdi Division decided, and now was very categorical, that inter and intra-union disputes cannot come to NIC in its original jurisdiction. It must go through the processes of Part 1 of the TDA before it comes. The unfortunate thing is that the 2020 Court of Appeal decision in Makurdi Division did not cite the 2016 decision of the Court of Appeal Kaduna decision. Secondly, the 2026 decision of the Court of Appeal of Kaduna Division related to a cause of action that arose prior to the third alteration. But the 2020 decision of the Makurdi division of the Court of Appeal was decided based on a cause of action that arose after the third alteration. And the Makurdi division even relied on section 254C3, I think, in coming to that conclusion. So as between those two decisions, the tendency is to say, okay, the Makurdi decision, apart from the rule that says take the most recent one, if there appears to be a conflict, I don't really believe two cases can be conflicted. But despite that rule, the point is that the 2020 decision, more on the third alteration, should be a preferable decision. The only problem with the 2020 decision is that it also held that even the interpretation jurisdiction of the court, you know, the NIC has jurisdiction to interpret some documents, IAP award, constitution of the union, decisions of the court itself, a memorandum for the settlement of a trade dispute. Now, in giving us jurisdiction to interpret, starting with the Trade Disputes Act, the understanding was that for interpretation jurisdiction, the jurisdiction of the NIC was original. But today, with this Court of Appeal decision, I think it's Nasu versus Jacob, we've been thrown back and told that even for that interpretation decision, it must go through the process of Part 1. Now, there's a huge debate and so many cases, particularly Court of Appeal decisions, on the question whether the Industrial Arbitration Panel, for instance, can make declaratory relief, can grant injunctive relief, or, as regards the point I'm making, can interpret documents, laws, and the like. Of course, there's a case I did where I did analysis of some of these issues. I made distinctions. Inherently, I looked into the definition of an award. AIP's power is to issue an award in respect of the disputes that are referred to it. And the question is simple. If you say it cannot make declarations, what is a declaration? It was Justice Oputa of blessed memory who said a declaration is merely a statement of legal rights. Now, if IAP is to make an award, will it make an award in vacuum or after determining who has a right and who doesn't? So strictly speaking, and inherently within the concept of an award is the determination of legal rights. And of course, usually they can make award often monetary. But even at that, it's not uncommon to find IAP saying or telling the parties before it, you can do this, you cannot do that. The moment you say you can do something or you cannot do something, is that not an injunctive order? So some of these things came up. Now, the point I'm making is within the structure of the National Industrial Court Act, we had these little variations, which were done deliberately to do away with some conceptions, judicial conceptions that we felt did not bring out the true meaning or were bound to create issues. And the two principal ones were inter and intra-union dispute and even the concept of trade disputes itself. Of course, that was built on in the third alteration. The whole idea was, if you look at the history of the jurisdiction of the NIC, in 1976, when the Trade Disputes Act Decree 7 was passed, the jurisdiction of NIC was restricted to trade disputes. In 1992, inter and intra-union dispute was added. In 2006, you had labor, industrial relations, trade unions, and whatever added. Then in the third alteration, you have the expansive and virtually widening of all areas of labor or employment law within the structure of the jurisdictional scope of the court or the jurisdictional mandate of the court. Now, if you look at this trend, what you find revealed is a gradual ascension. In other words, a deliberate policy where for each law, something was added to the jurisdiction of the court. And sometimes when we interpret this law, it may be necessary to also have these historical antecedents in mind. It cannot be that the legislature didn't know what they were doing. It was deliberate. And why was it deliberate? Go to the Constitution. Everything under the exclusive legislative list, except item 34, is within the exclusive jurisdictional power of the Federal High Court. In other words, for federal causes and matters, go to a federal court. And the federal court is the Federal High Court. Only item 34 was omitted. And item 34 deals with nothing other than labor and industrial arbitration. So if the National Assembly wakes up and says everything that has to do with labor, industrial arbitration, and so on should go to a specialized court, it cannot be that they don't know what they are doing. And that's why when you look at decisions like Skybank and Iwu, there was a huge misunderstanding of the basic essence of what even the National Industrial Court stands for. If you read that particular decision, the submissions were simple. Oh, you need to cut this court to size. They are trying to compete themselves, make themselves like a Supreme Court and so on. Incidentally, I was on the first day that matter came up at the Supreme Court, and I remembered vividly, it was Justice Nweze who asked the Respondents' Counsel, this thing you wrote to us on an address, do you think it is sufficient to resolve this huge constitutional question that is before us? And the Respondent Counsel said, yes, he was okay with what he wrote. And Justice Nweze replied, what we need is a comparative constitutional provisions of other jurisdictions for us to know. And unfortunately, maybe because the council didn't know, Nigeria is the first and so far the only country with the constitutional provision of Section 254C of the 1999 Constitution. There is no other country with that kind of provision. So the question of a comparative analysis of constitutions of other countries does not even arise, because you are not going to find one. It's only Nigeria. The only question that was relevant, and which I think all missed, including the revered justices, was whether there are countries in the world where the right of appeal from an industrial or labor court does not exist. I've done my own research and I was able to discover about 5 countries where the labor court is final. So on that score, Nigeria was not doing anything special. There were other countries where the labor courts are final. And why is it that you even need a labor court to be final? It's a very simple thing. Labor cases are time-bound. I like giving the example that disputes over collective agreements are usually, collective agreements by nature are usually 2 years. So if you have a dispute over a collective agreement, and for the next 10 years you've not resolved it, it means by the time you're getting an answer to your problem, that company or that organization would have been maybe in their 5th new collective agreement. So by the time you are getting an answer, you are getting an answer that librarians would like to call dated. When they say a book is dated, it means it's out, it's no longer, it's outdated. So you are going to have a judgment that is dated, useless to all the parties who went to court. And in labor adjudication, we have this principle, and I think lawyers need to have it in mind because it shapes globally. It's a global principle. It's not just a principle applicable to Nigeria. And the principle is very simple. In labor disputes, it's better to get a bad judgment quickly than a good one too late. I will repeat it. In labor disputes resolution, it is better to get a bad judgment quickly than a good one too late. We're all familiar with the case of Ebuebi and CBN. It took 23 years. It was a dispute as to whether the man had gone to court. He works with CBN. He had gone to court challenging the dismissal, his dismissal by CBN. And the issue of jurisdiction came up. Is it the state high court or the federal high court that has jurisdiction? That went up to Supreme Court, and it was not answered until 23 years after. By the time the Supreme Court was deciding the case, third alteration was already invoked. So neither the Federal High Court nor the State High Court had jurisdiction over the matter. So Supreme Court said the matter should be sent to the NIC. And my colleagues in Akure were saddled with the burden of having to decide that case. I remember vividly my colleague in Akure told me anytime the case was coming up, both the counsel to the claimant and the claimant himself, who were now way into their 70s, were coming to court with walking sticks. And the sad thing was that that case was not resolved at the point the claimant died. In other words, the claimant died without knowing whether his dismissal was correct or not. I'm told that it was after he died that the CBN now came up and told the family that they should come so that they can settle out of court. By which time, cumulatively, they have done, I think, more than 27 years in taking that case. So the question now was, if at the point he was dismissed, a court of law simply told him that, look, your dismissal is correct, this man would simply have went home, gotten over that, reordered his affairs, and move on with life. But 27 years after he is dead without knowing an answer, and some negotiation is being done with the family, I'm not too sure that that's the kind of labor regime we want. So I go back to the principle. It's better to get a bad judgment quickly than a good one too late. And don't forget, labor rights are essentially rights in rem, my rights in personam. They are not rights in rem. When you're fighting a land dispute, you're fighting an election matter, okay, you can go all the hog, all the technical rules of evidence, you can do all of that. But when it comes to employment law, these are not issues that are bogged down by technical rules of evidence. And that's why, for instance, in our section 12 of the NIC Act, it stated that, yes, we are to apply the Evidence Act, but in the interest of justice, we can depart from it. A lot of people don't seem to see sense in this provision. Nobody is saying that justice is not going to be done, but look at our Evidence Act. Look at the rules on public documents, the requirement of certification. Older people who had worked in government understand before now that the originals of documents were in a file. And if an action arises, it means you must carry the whole file and go to court. But it's to do away with that they say, okay, go and certify it, that portion that you need, and bring, so that you don't halt the work of government. Today, you don't find those kind of files because every document that is generated from a computer, sometimes the same document, you can have 100 copies. So if you have that kind of setup, do you still require the necessity for certification? And in the world of work, even the identity card of an employee is not his own, it's the employer's. The day they sack him, the first thing they collect is the identity card. So if he comes to court and says he wants to prove, and an issue has to do with him tendering the identity card, often he has none. And I'm very sure majority of us who are employees, including judges, you don't have photocopies of your ID card kept somewhere. So the question of saying, okay, do notice to produce, and if there is none, you tender secondary evidence, does not even arise. And in any event, when some of these documents are not being impugned on the basis of authenticity, why should it matter that those strict rules of evidence are not followed? We are all living in the modern age. We all have bank accounts. You do transfers on phone. If you do a transfer on phone now, a receipt comes to your phone immediately, indicating you did the transfer. If you go to court and you have to prove that now, the Evidence Act talks to you about banker's book. You must go and bring a banker to bring banker's book and so on. For God's sake. What am I trying to say? We are saddled with laws that were made in an era that is difficult to replicate today. And if as lawyers, as judges, we cannot put heads together and understand that in law, context is everything, and we need to contextualize these things and apply them with a better sense of justice, then we are in for trouble. And nowhere are you saddled with this more than in the world of work, where you're dealing with people's life, you are dealing with people's livelihoods. I have seen in cases before me where even the conditions of service were taken away. In fact, if you go to most establishments now, the conditions of service are online. If you are a worker, you have a password to be able to access it. And they are usually put in such a way that you can't even print out. So the day they sack you, you can't log in. And because you can't log in, you can't even access the conditions of service. And yet, we expect strict rules of evidence to work and so on. These are problems, no doubt. What we have done within the structure of NIC, if you take some of our cases into account, you would find that, yes, sometimes we are conscious of the necessity to do justice to all parties. I know people have accused the NIC of being an employee court. I've only said, go and take a sample of our cases. They are all on the website. Take them and ask yourself a simple question. How many did the employer win? How many did the employee win? In fact, some few days ago, I did a judgment where I foreclosed the defense from entering defense because they were reluctant to file processes within time. When I foreclosed them, they filed up to 5 motions, trying to do 1 or 2 things to come in here and there, all of which didn't succeed. The day I read the judgment, incidentally, the claimant couldn't even prove his case, and so the defense, without even entering a defense, won. The point I'm trying to make is that it's not so much about NIC is an employee court. It is so much about whether NIC in individual cases is doing justice according to the facts that come and according to the law that is being applied. One other thing I need to stress, and this has to do with lawyers. Sometimes it's baffling. A lawyer goes and files a case where he knows there is no jurisdiction. Nobody raises the issue of jurisdiction, and consequently, a decision is done without reference to some things. Now, look at this scenario. NIC is the only court in the land that constitutionally is allowed to apply international best practices and conventions, recommendations, treaties, and protocols ratified by Nigeria. No other court has that. What this means is this: if 2 people are sacked based on the same circumstances, the same facts in an organization, and one chooses to file his case in NIC, and the other chooses to file in a high court, the outcome can never be the same. The outcome can never be the same. I'll give you a simple example. There is a Court of Appeal decision regarding termination, which says in an employment where you are being investigated for a disciplinary issue, you cannot resign. You cannot retire. In other words, the employer has the right to reject your resignation. Of course, there are other Court of Appeal decisions that say resignation is an absolute right of an employee. Now, the matter came before me, and the issue now was whether the employer who rejected notice of termination was right. Of course, I looked at the Court of Appeal decision that was cited before me, and I asked some 2-3 simple questions. Was Section 34 of the Constitution, which deals with forced and compulsory labor, cited? The answer was no. Was there's a relevant provision dealing with compulsory labor under the Labor Act? I asked whether that was also cited. The answer was no. And then I asked the third question, was the ILO Convention on Forced and Compulsory Labor cited? The answer was no. Now, Nigeria has ratified the ILO Convention on Forced and Compulsory Labor. And if you read the ILO literature on that subject, ILO is very specific that the right to leave work by an employee is absolute. In fact, that even where you are investigating an employee and the employee chooses to go, he has the right to go. If you stop him, that from that moment that you stopped him, what he's doing is forced or compulsory labor. And that tallies with the constitutional definition of forced and compulsory labor under Section 35 and the one under the Labor Act. So I interpreted the Court of Appeal decision as one that did not look into these laws. And I distinguished the Court of Appeal decision on that basis, applied the International Labor Convention on Forced and Compulsory Labor, and held that the employee had the right to leave, and that the refusal to accept his resignation by the employer was tantamount to an unfair labor practice, and I ruled on that. Now, only an NIC can do that. The High Court cannot do it because it does not have the constitutional mandate to do. So when you have a case that can be decided based on some of these international instruments, I've had civil society, for instance, argue left, right, and center about, I think, the last constitutional dispensation, half of which was the directive principle should be made constitutional, this and that, and so on. And I'm like, the little one that has been given to you, how have you used it? If you go to the directive principles, most of those principles are principles in international instruments that Nigeria has ratified. And once they relate to the world of work, it means NIC can apply them. You can litigate them in NIC and be recompensed on them at the NIC. But how many have been done? I'm not aware of. So sometimes we like to do things without even justifying the little that we have. I'm sure I must have taken too long. Let me stop here and take questions. Chairman, let me take questions here.
Yeah, thank you very much, my lord. Very incisive, very articulate. I mean, I'll comment generally on the presentation after question time. Permit me to invite Mr. Folabi Kuti, Senior Advocate of Nigeria, to lead us through question time. Folabi, the floor is yours.
All right, thank you very much. And let me start by thanking my Lord, the Honorable Justice B.B. Kanyib, PhD. I must say that, of course, I think I'm used to it, that time is never your friend when you have my Lord taking on any of these areas, the corpus of the new labor jurisprudence. And today, again, my Lord has done justice, incisive thoughts, illuminating position, and interesting interrogation of the subject matter. A couple of questions have come up, my Lord, and I will just, reading through, it does appear as if some, my Lord, has actually touched on in the course of our presentation because of the very limited time that we have. I'll just go straight to very few, and I would ask my Lord to perhaps help us address that. Now, the very first one, which I have here, has to do with triangular employment. The question has been posed thus rather. Good afternoon, my Lord. My Lord, I'll pose my question using a scenario. An employer went to a site with his workers. At the work site, 2 workers were lifted to the top of the roof with a crane operated by a staff of another company. While on top of the crane, the staff negligently left the crane unattended to, and the workers on top of the crane got loose and fell to the floor, sustaining severe injuries. On the work site, workers were lifted to the top of the roof with a crane operated by a staff of another company, and who negligently handled it. I mean, those who were working on it, some fell on the floor and sustained severe injuries. Now, this colleague has painted this scenario, asking that, my lord, who bears the liability? The employer or the company who employed the negligent staff? I would imagine that this is a case scenario that if we were to come before the industrial court, how would my lord address it?
Before you go on, let me just answer that before you go on.
Yes, my lord.
There is a principle I like to call the Privity Fallacy. You know, we are straight. I keep talking about law must be understood in context. In law, context is everything.
Correct.
We are held back. Privity rule is a common law rule. And the rules is simple. If you are not a party to a contract, you can't benefit from it, you can't suffer from it. Yet, we know that in complex commercial contracts like the one you've given, there is the intermediary of so many actors.
Yes.
And in the area of outsourcing, for instance, what some try to call triangular transactions, you know, within a contract that is within an outsourced contract, there are different grades of outsourcing.
Yes.
Now, like I said, there's a principle I like to push forward. It's not a principle that has been recognized by the highest court, but fortunately for us, I think Justice Afen of the Court of Appeal, when he was at the FCT High Court, alluded to it, the Privity Fallacy. The Privity Fallacy is very simple, that look, when you have this complex arrangement and you have this kind of scenario that you are doing, you don't need to be straitjacketed by the privity rule. You look everything as a composite whole. And luckily for us, within the context of employment law, we've recognized that it is possible to have more than one employer. Remember, I talked about the identity crisis of labor law, and I only alluded to the point of we don't know who an employee is, particularly today. There's also the caveat, we don't know who an employer is. If you go to Section 91 of the Labor Act, an employer is defined to include manager, agent, like that. And if you look at it, I've seen cases where people have come before me and said, look, strike out the name of the managing director. He's, you can do without him in them. I said, no, go to Section 91 and read the definition of employer. It includes agent, it includes factor, it includes a host of others. In the world of work, there's also the problem of determining within a structure. There are some people who work in a workplace and other than their immediate supervisor, don't even know who the boss of the place is because they've never had any reason to interact with them. So if anything happens to him, as far as he's concerned, it is that supervisor that is his employer. Modern systems are de-emphasizing those straight-jacketed theories about an employer being one white-collared man sitting somewhere, and said, no, look at the general texture, the complex of the relationships. If it means even holding more than one responsible, so be it. So long as at the end of the day that the person who is injured is able to have. And I think in one of my writings and a ruling, I was even able to make distinctions that, look, sometimes we should also be careful how we use the word employer-employee because it means different things for different purposes. For employment protection law, employer-employee means one thing. For vicarious liability, employer-employee means a different thing because for purposes of vicarious liability, even an independent contractor is said to be an employer, which may be what will happen in relation to the outsourcing question you gave. And for tax purposes like employment tax, the concept of employee-employer is different. So depending on the context in which it is used, I have seen lawyers write briefs and argue, citing, you remember that I said something about miscitation of cases and mixed contextualizing it. I gave the example of political parties and trade unions. Another example is, I have seen cases where lawyers cited cases of vicarious liability to try to tell me who is an employee for employment purposes. And I've had cause to say, no, that's wrong, because you are not even understanding the context in which it was made for you to be. So there's that need to be careful. Coming back to the outsourcing problem, I won't say this is how we are going to decide it. It remains hypothetical. But based, again, depending on the judge who will hear it, because I may not even be the one looking at it anyway. But like I said, globally, the privity fallacy now says, when it comes to issues like that, don't look at the two immediate parties in the relationship. Look at the context, the structure, the commercial structure in which the transactions were done. Then if it means holding all of them, in the area of consumer protection, the Americans have been able to develop what is called the enterprise liability theory, where you cannot catch the immediate tortfeasor, the immediate offender, catch the industry. That's the theory of enterprise liability. In other words, if, for instance, an injury is caused by generic goods, generic drugs, for instance, that you cannot pinpoint the exact company that did it, the enterprise liability theory in consumer protection dictates that catch everybody who is in that industry and make them to pay. The justification for that is this, that it is the industry that is what is called the best briber. They are the ones who can prevent the accident. They are the ones who can work on the product to make it better. They are the ones who can find who will be able to find a solution to making the product better. Now, for us in Nigeria, we are gradually coming to an area where we may begin to borrow some of these terms, some of these principles, even if it is in other areas of law, to resolve some problems within a particular area of law. So if within the structure of this outsourcing example, that thing happens, for me, you look at the basic structure. If it means holding all of them complicit, you go ahead and do it. S.M. Folabi.
Oh, thank you very much, my lord. I got carried away with the example that my lord gave, and I was almost tempted to pose a follow-up question to that. That yes, because the concern there is that it does appear as if the court is beginning to sidestep what appears to be the common law arrangement of an understanding of privity of contract as between parties. So a third party or somebody or a third party who ordinarily didn't appear to be within the contemplation of the contractual arrangement is now being made to bear liability or being made to bear some rights or an obligation and all that. To the extent that my lord, beautifully gave examples and the thinking, the modern thinking in relation to this particular area. To the extent that there does not appear to be a legal framework, would it make any difference if, for example, it's something that is thought of and then perhaps reduced into a statute? Would it make any difference, my lord?
In England, for instance, the privity rule has been eroded, principally by statute.
Yes.
But the point is this, you can't wait for statute to fill these gaps and create a solution. Today, we are talking about technology, right? I did a paper the other day and I drew attention to injuries caused by software.
Yes.
Now you buy a particular software thinking it will prevent hackers. Unfortunately, the software does not solve that problem. Hackers hack into your computer and everything is lost. And the question is, how do you go after the software manufacturer? If you say you are going in contract, there are fine lines that exempt liability. But you know, Donegal and Stevenson came about because of the difficulty of attaching liability in contract. So we are living with this thing day in, day out. And for us as judges, it's foolhardy to think that we will keep waiting for the National Assembly, the legislature to do this, to do that, do this, do that. At the end of the day, you see, again, I have to throw it back to lawyers. It's like computers, garbage in, garbage out. If you have a lawyer not too long ago, despite the thinking of everybody that, look, a governor can change parties and so on, was it not a judge who decided that, no, you can't just change party and still be in office? There are some things that need to be done. I always like when I was teaching to give the example of Rylance and Fletcher. Go back and take that decision. It's a House of Lords decision. Read it. Not one case was cited, but it was decided based on analogy of existing principles, which were drawn and coupled together by the House of Lords to give us what today is the rule in Rylance versus Fletcher. Now, why can't lawyers do the same in their presentation and urge the judges to agree with them? The judge cannot go outside your presentation, only in rare cases. Otherwise, you accuse him of jumping in the arena. You write petition against him for deciding a matter based on some. I've seen a petition against me where I told counsel, go and read this case and tell me whether I have jurisdiction. And in fact, an SAN, for that matter, wrote a petition and said I didn't give him opportunity to address me on a case, and I used the case. Meanwhile, the Evidence Act says I must take judicial notice of existing case. So you find these things on ground. And my argument had always been, how innovative, how creative are the lawyers themselves in presenting some of these arguments? Because if you don't, of course, I'm not saying you go like a lawyer did before me in Lagos, that he filed a case because he wants to develop the law. And I said, no, to develop the law is an abuse of process, because that's not part of the interest of justice. You don't come to court because you want to develop. You have to come to court because somebody has been injured or an injustice is committed. Yes, SN.
Thank you so much, my lord. I mean, the elucidation my lord further offered on this leads to a related area, because I see my lord referring to cases defined within the corridors of thoughts, and to perhaps further stretch the argument that yes, it can affect or it can include a third party, depending on the scenario at hand. And there are a couple of questions along that line, asked in different ways, but I think what I make out from about 4 questions here is, what really is the jurisdiction of the industrial court in tort-related matters, howbeit arising in the workplace, defamation and related stuff? Can we,
right now,
do we have a certain position?
Right now, there is no certain position. In fact, I like to give the example of a particular case in Benin Division of the Court of Appeal. The same case, same suit number. 2016, there was a ruling that says it's the High Court that has jurisdiction over libel. In 2018, the same case, but a different panel decided that NIC has jurisdiction. And not too long ago, I think in 2021, I read of a particular case where the Court of Appeal said they've gone back to the original position that the National Industrial Court does not have jurisdiction in defamation and, of course, by extension, other kinds of torts. Now, this is my position, and I have ruled on it that way, although the Court of Appeal decision I spoke to you, the 2018 decision, overruled
yes, my lord. Yes.
Our position. My personal viewpoint is that, except for workplace injuries, and that's because we have jurisdiction over Workmen's Compensation Act, or the act that replaced it, except for the thought of interfering with contractual relations, which, if you read the history, emanated as a result of employers suing trade unions for going on strike and stopping them to satisfy contractual rights to third parties. I don't think NIC has jurisdiction over torts generally. In other words, whether it is defamation, whether it is conversion, whether it is detinue, whether it is false imprisonment, whether it is trespass, I don't think. And my reason is very simple. These are torts that are torts in their own right. And when you are determining whether there is liability or not, you are not going to use employment law. You are not going to use employment law. There are torts that are what you may call sui generis. In other words, they can found causes of action in their own right. So for me, if you come to me and you say my employer defamed me, you can go to a high court and file for defamation and prove it. And people don't even understand, and I have seen it before me. There are two aspects when it comes to defamation. There are two aspects we need to note, and I need to make this point here. Defamation can be cited for purposes of calculating damages. If you read cases like British Airways and Makonjola, it talks about if what the employer does influence or added to the injury, or that's injury to or beyond termination, that is an item to be used for calculating what additional damages should be paid. So if your termination is like in the banking sector, once you say somebody is terminated, the man will never get a job in the financial sector in Nigeria. So the damage, you don't even have to claim for defamation. The damage is already inherent. But there is also defamation where you need to prove those three requirements. There was a defamatory imputation, it refers to the plaintiff, and there was publication. Then if it is slander, there was resultant damage. What I have seen in NIC is that people come, they want claims in respect of the defamation of character, this and that. And the man then comes to his pleadings. He does not even particularize the defamatory imputation. All these things about the innuendo and so on, he does not even, of course, I have had to just rule that, look, this man is claiming in defamation. He has not been able to prove the requirements needed for proof of defamation. Consequently, that claim fails. It is hereby dismissed. The disadvantage here is this. You can no longer, after that judgment, go to a high court, because there is now a decision on merit by a court of coordinate jurisdiction to the high court. So when you see lawyers lump these claims simply because the defamation is attributed to an employer, oh, let's go to NIC. In fact, sometimes they come to NIC on the assumption that, these are people who are not well read. We can get judgment anytime, any day. I always tell lawyers who come before me, if you think you can wake up in the morning and go to NIC and win a case, you are joking. You will do more work than you are doing at the high court, because ours is different. You don't carry what is at the high court and bring to us. You will have to learn what we are doing to be able to succeed before us. I have made that point not once, not twice. And I have made them severally in my judgment. But lawyers, of course, like I said, maybe they don't even read the decisions we make. For me, coming to NIC, the starting point has to be the judgments of the head IC. You have to understand what the court is doing, how it is doing it, before you can now say, look, this thing goes against a court of appeal decision. This thing goes against a Supreme Court decision. But like I said, you must be able to do that within the context in which it's been done. I think Justice Ogaku's decision in Sahara is very apt, and is some for those who practice in NIC. For me, that decision is like a gospel. Commit it to memory and you will not get lost in NIC. That's my position on that matter.
My Lord, I mean, from one to another related one, yes, I mean, lawyers who practice in regular court beginning, we thinking that we can bring what obtains in the regular courts to the NICN. Leads me to what appears to be a big elephant in the room, especially for lawyers who act for employers. There's this concern, and it's been expressed in about 3 questions there, and I'll just summarize it with this particular one that says that my Lord will agree that our jurisprudence on labor law will not be developed when the court relies on international best practices to the exclusion of the contract of employment, I mean, sometimes, and the peculiarities of the Nigerian economy. I mean, drawing international best practices to deal with Nigeria with its own domestic peculiar issues and all of that. Are we not almost like throwing away what we could say is our homegrown experience or jurisprudence?
Let me start by saying, even before the jurisdiction over unfair labor practices and international best practice was given to NIC, there are Court of Appeal decisions I have read that are very specific, that no court of law should allow an employer to go free where the terms of the contract of employment ensure that the employee is put in some kind of servitude. In other words, if an employee is asked to work in what the Court of Appeal terms servile conditions, no court of law should allow it. I didn't say that, it's Court of Appeal, and it was said prior to third alteration. So the truth of the matter is that, firstly, we are not even conversant with the general case law that existed even before third alteration. SN Folabi Kuti, don't forget, yes, Makonjola was before third alteration.
Yes,
The justice in that Court of Appeal decision was foresighted. For him in I think it's a 1993 decision.
93,
for him in 1993 to say, look, it cannot be that an employer who sacks an employee and refuses to give him even that notice period or the payment in lieu of notice, and waits for this man to go to court for the next 2-3 years is fighting, then the court turns around and says the measure of damages is what should have been given to him as notice pay or whatever. That's grave injustice. The Ghanaians started it. It took this Court of Appeal decision in Nigeria to recognize it. But of course, after that decision, no other Court of Appeal decision looked at it. We all reverted back to the common law. And I always tell people, you wait until, don't forget, judges too are employees anyway, in a sense. Don't forget. So whatever rules we make, we suffer it.
Yes.
I always tell people to go back and read the Court of Appeal decision in Longe and First Bank, which went up to Supreme Court. It was Justice Salami who decided it and then laid down the structure of suspension. When he had issues with the NJC, everything said there were the same things that were put in place in terms of the suspension. So sometimes you make this thing and have to understand that, yes, we are all in the world of work. I did most of my research study in consumer protection. And one thing I like to tell people is that you may be a producer, but don't forget, in another sense, you are a consumer. So take, for instance, the owner of an airline can claim to be a producer, a supplier of service, airline services. If you want to hold him responsible to delaying workers, passengers in one sense or the other, don't forget, he's going to oppose you and tell you, no, no, no. But tomorrow, he's going to enter some other person's plane to go to another country. And when he suffers the same fate, he ought to remember that he too was doing like that to some other person back home. So yes, in our different capacities, we may be one thing in one capacity and another thing in another capacity, but we must never forget there are some areas of law, and employment law is one of them, consumer protection is another, where, like I like to tell people, there is what you call, in a strict sense, you call judicial subsidization of even the liability rules, where deliberately or otherwise, if you take consumer protection, for instance, what we call the foolproof production process rule says if a manufacturer comes to court and says and he brings somebody who goes to the witness box and says my production process is foolproof, it is for the consumer to disprove it. The question is, how can a consumer ever disprove it when he doesn't even have access to that process? He does not have the technical know-how. He does not have the resources to get somebody who will go and do it. So sometimes when we decide cases, I remember vividly, I don't know if you have remembered this case, Imo Concord Hotel versus Justice Anya.
Yes, sir.
If you remember that case, there was an earlier case, EKE or
Yes.
something, I've forgotten the name, versus
Yes.
this hotel in Jos, Hill Station Hotel. The issue was whether a hotel guest who parks his car and the following day the car is missing, but his car key is still with him, whether the hotel is liable or not. I remember vividly, it was Justice Idozie who was in Court of Appeal who decided the Hill Station case. And he decided that the hotel was liable. I wrote a paper on it. I criticized the decision because for me, the parameters upon which that decision was held were not parameters that will help anybody for purposes of precedent. Years later, when Justice Idozie got to the Supreme Court, he decided the Imo Concord Hotel and Anya. The unfortunate thing was that throughout that decision of Imo Concord Hotel and Anya, Ike and Hill Station was not cited. And in Justice Anya's case, it was held that the hotel was not liable. Same fact, same story, same circumstance. Of course, for us, here I'm talking not as a judge, maybe just as somebody who is concerned. There's no way you can reconcile those two instances. Same judge, same facts, same scenario, different result.
I was going to assist my lord that just talking not just as a judge, but as the author of one of the leading texts on consumer protection law, in addition to the employment law aspect that my lord does at the NICN. My lord, I
wrote a paper. Just a minute. I wrote a paper on the law's treatment of economically disadvantaged groups, and I zeroed in on consumers and workers. And my conclusion is that the law generally is disproportionate against them. That's my conclusion. And throughout my work, even when I was doing my PhD in consumer protection, it was a thesis I was out to prove, which is the law generally treats economically disadvantaged groups worse than it does to the same economically advantaged group that it has to relate with. In consumer protection, you are talking of the relationship between consumers and producers. In employment law or labor law, you are talking of the relationship between workers and employers. Workers are fairly better because over time, they've been able to aggregate themselves into groups called trade unions. Consumers have not been able to group themselves. So they have to be treated in their individual basis and individual capacity. And that is why, while there is a measured paternalism with the law in labor law, you don't have that paternalism in consumer law. But elsewhere, if you go to places like in US, you go to UK, the paternalism of the law is being seen in legislation. Back home here, we don't see it even in legislation. At least nobody in the National Assembly is talking about the plight of consumers. And the consumers come in different forms. You have consumers of aviation services, you have consumers of banking services, you have consumers of electricity services, you have, since all the blackouts we've seen and so on, what concerted, how do I put it, concerted reaction have you seen to show that the consumers have grouped themselves with one voice and complained as consumers? And don't forget, starting with Mr. President down, all of us are consumers. Like I like to put it, the state of development of a country is measured by the level of consumer protection existent in that country.
My lord, we can go on and on, but I've been told that we are out of time for this, and I need to revert back to the DG of the ICLE. And of course, I'll leave him to do the honors of thanking my Lord for this very brilliant session. Okay, yes. Tobina, please. I can hear you, Tobina. Go ahead. Yes.
Subject to my Lord's convenience, I mean, I think we could take a few more questions because you have
fantastic
about 57 questions hanging there.
Oh, and it's going to say yes.
And you have over 1,000 people viewing across platforms. So please, I think the interest has been good, and watching the movement of people dropping. I think
fantastic.
We'd have to fix time on this occasion. My Lord, I hope we're not imposing on you, please.
No, it's okay.
Fantastic, my Lord, and thank you very much, Tobina. It's a privilege to have my Lord on this session. Let me take 3 more questions. I can take
15,
more questions.
Another 15 minutes is fine.
Okay, fantastic. Okay, my Lord, 15 minutes, quite a number of questions jostling for attention. But let me try and categorize into 3. One is been recurring, relates to what my Lord's thoughts are, or by extension, the industrial court's thoughts are on the issue of the applicability or the extent of the applicability of the Arbitration and Conciliation Act, which is the principal statute dealing with arbitration in Nigeria, to employment disputes that have been submitted to arbitration. And for one reason or the other, perhaps for enforcement of award, they are now being brought forward to the NICN.
The point I'm trying
jurisdiction, yes.
The point I try to make is this: if you file a case in NIC and for a verdict you rely on the Arbitration and Conciliation Act, it will not fly. But if on your own you go and decide and resolve a dispute using the Arbitration and Conciliation Act, and you merely want it enforced, or under the power and jurisdiction of the court to interpret memorandum of understanding for the settlement of a trade dispute, if you come either for that interpretation or for enforcement, we will listen to you. Because then we are not looking at the merit of the arbitration. We are simply looking at how you are going to enforce it, because the law gives us power to enforce. But where you are seeking for a liability right, a liability verdict, using the Arbitration and Conciliation Act before NIC, we will tell you no, because that act is primarily meant for commercial contracts or commercial transactions, and labor transactions are not one such. But if you have entered into and concluded, and you merely want enforcement, if you come to NIC, we will listen to you.
My Lord, thank you very much. I jump straight to the next one. It relates to the power of the courts of the NICN in the implementation of the punitive section of the Employees Compensation Act 2010. And the question goes to what extent does the NICN play a role in the implementation of the punitive sections of the ECA in order to mandate the compulsory registration of recalcitrant employers of labor with the Employees Compensation Scheme under the NSITF scheme? I mean, the question and related to that is, can an employee whose cause of employment is prone to workplace hazard sue his employer to register with the Employees Compensation Scheme?
My answer is very simple.
Yes.
And is built on this scenario. I am injured. The law says I can claim under common law negligence, in which event I cannot claim under Employee Compensation Act, or I can claim under Employee Compensation Act, in which event I cannot come to NIC in its original jurisdiction. I must exhaust all the processes of the Employee Compensation Act before I can come to NIC as an appeal over the verdict of the NSITF or the board or whatever that is charged with making that body. But there's also the other issue. I am working in a place where I am injured, but the employer did not even register for purposes of Employee Compensation Act. Here, your cause of action is what is strictly called statutory negligence. I don't know whether you note that difference.
The difference, very
For
clever.
failing to discharge a statutory duty, you can hold an establishment liable, particularly where the failure to hold that statutory duty resulted in injury to you.
Yes.
Your cause of action will be not a claim under Employees Compensation Act because the body is not registered and
Yes.
NISITF will not recognize you.
Yes.
Your cause of conduct or action is to file for what is called statutory negligence. In other words, the inability of your employer to register as a unit for employee compensation purposes.
Yeah.
And then, of course, you read the literature on statutory negligence and see what you need to prove and what you don't need to prove and things like that.
My Lord, thank you very much, for that very incisive response. And I think these two sets of questions together, there's a pointed one that's asked, is the Labor Act applicable to all employees? That's one. And maybe not too related, but I thought my Lord can take alongside is a question asking what the position of the law really is on an employee who on an employee on probation whose employment was terminated without notice.
Let me start with the second one. It's almost nil. An employee on probation almost does not have any rights if the cases even decided by NIC are to be taken into account. So he's really on a precarious position. The straightforward answer is that he has little or no rights whatsoever. But depending on how the contract is couched and the applicability of the, I think I read of a Supreme Court decision, is an old one that said even on probation, you are entitled to notice period. So it means beyond the right to be given that notice period and maybe compensated for just the salary for the notice period, you really have no right. In other words, the question of reinstatement and things like that will not even arise at all. Now, to the question whether the Labor Act applies to all employees is a neither here nor there answer. The Labor Act defines workers by reference to virtually junior staff. So what it means is this: if the provision of the Labor Act sought to be applied uses the word worker or workers, you must go back to the definition section and apply it to only those who come within that definition. But if the provision talks about person, it means it goes beyond workers and applies to whoever the law defines as a person. You are not going to find the definition of a person in the Labor Act. But if you go to the Interpretation Act, it talks about person being natural or artificial. But again, for purposes of the Labor Act, the question then arises, can an artificial person be a worker or be a person for purposes of labor rights? So it all depends on the context. That's why I said it is a neither here nor there question. Now, I know that within the structure of NIC, sometimes we use the Labor Act. Don't forget, the Labor Act is supposed to be the repository of the minimum standards required in a workplace. And I've seen decisions in NIC where the Labor Act had been used generally as evidence of that minimum content of labor standards required. Now, under the current dispensation, NIC is asked to apply international best practices. Now, if the Labor Act, even though applicable to workers, provides a minimum standard that is good for workers, by analogy, NIC always reasons it should also be good for even employees who are higher than workers, on the basis that the justice of the case requires applying good international standards. So, the Labor Act sometimes is used as a source of policy for determining the kind of standards that should apply at the worst as a minimal level of standard. But like I said, your first part of, like, I'll give you a simple example. The definition of employer in the Labor Act, we have applied that definition without reference to whether it relates to workers or to employees who are not workers in the strict sense of the definition of Section 91. But we have applied it for the simple reason that on the grounds of principle that the categories of employer is enlarged, it is something that should apply not restrictively to workers who are junior staff, so to speak, but generally in the workplace as a standard. So when you come to us and you say, I sued this body and I sued their managing director, and the argument is that the managing director is not a proper party, I will go to the Labor Act and say, no, the Labor Act recognizes a managing director as agent, factor, or so, as an extension of employer.
Yes.
So on grounds of policy, on grounds of a wider minimum standard as to who an employer is, I will carry it and apply as a judge of NIC. So the Labor Act, apart from being applicable to workers in the strict sense of the word, is a source of policy. It's a source for determining what the minimum content of labor standards is. And if the need arises, it is applied as such.
My Lord, there were further thoughts in relation to that, but I'm looking at the questions and I would really want my Lord to cover these questions, and then we can return to that if we still have time. There's a recent trend in the industrial court where judges of the court will appear to want to review the decisions of disciplinary committees set up by employers. The question is asked, has the position of the law changed from what it used to be? That is, a court will not review such decisions insofar as, one, there's a laid-down procedure that was followed and the employee was given fair hearing. So I think the question is, to what extent?
Can I give you a simple scenario?
Yes.
The disciplinary committee recommended warning. The employer says, no, it's dismissal. Which will you take?
The disciplinary committee position.
Recommended warning.
Warning. And the employer says,
the employer says, no, this thing should go for dismissal, and he dismisses.
I mean, it's basically the disciplinary committee, and it falls within the context of the procedure has been followed.
Or
so in that case,
converse,
it is justified. Yes.
Or
yes.
The converse. The disciplinary committee recommended dismissal.
Yes.
The employer says, no, let's give him a warning. I have seen where the query issued to the employee on an issue was not what the disciplinary committee tried him for. I have seen it, both in practice and in case before me. The query he was queried on an issue and found guilty on something he was not queried. As a judge, what will you do?
Okay, my Lord, the court can intervene in such circumstances, clearly. But I think the question here relates to a situation where the court goes ahead to review the circumstance in which the decision was reached?
Well, unless I'm told the unless I'm given specifics, I won't be able to give you a categorical answer.
Okay.
On a general note, on a general answer, the answer is no.
Oh, fantastic.
But this is general.
Yes.
Like I said, this is general.
Context.
I have given you specifics because those are the ones I have seen.
Yeah.
I have seen queries on an issue and trials and findings of guilt on this, something that was not, or like the cases will tell you, you invite the man as a witness before you know it, he becomes a suspect.
Mm-hmm.
The cases will tell you, no, you can't do it. But I don't know whether what you are saying is that the judge goes in and says, no, this thing you wrote here shouldn't have been. I'll give you another example. I gave you the example of the Coca-Cola case. When I decided that case on merit, the disciplinary committee was supposedly consisting of, I think, 2 people. But when you read the report, the reference was to the first person singular. The worker, that's the employee, told me this. I did this. I resorted to this. And I was like, how can a committee of 2 all of a sudden turn down to I did this, I was told this thing was sent to me? And I said, no, there's something suspicious. If a committee of 2 people turns to I did this, I did, it means there's only one person who heard it. And for me, that cannot be a satisfactory report. So I turned down the whole report. As not representative of a committee report.
My Lord, I think let me bring this within the context of, recent happening or prevailing circumstances that COVID has imposed on us. On the world of work in the last few years. My Lord, the ECA defines accident in very expansive terms. It says an occurrence arising out of or in cause of work, which results in fatal or non-fatal, out of or in the course of work. So the argument has been put forward that in the light of the new faced world of work, the hybrid work from home work setting, which COVID has imposed on us, we may not agree that 2010 legislation is broad enough to include occupational accident that occur between the employer's physical workplace and or the employee's principal or secondary residence, as long as it's carrying on what you can say is work. So the concern here is whether there is a statute, there's a provision in the law, even though mid-2010, that can be brought forward to make an argument for the new workplace in the new reality of COVID, post-COVID workplace.
Of course, when that act was passed, nobody envisaged COVID.
Yes, madam.
And they tried to give a fairly expansive definition of cause of work.
Yes.
Relative to what existed under the Workmen Compensation Act.
Yes.
But even at that, I'm not too sure virtual workplaces were contemplated. If a problem comes up today, the question is, at the point this thing happened, was I working from home? In which event it's in the course of work? Because these are the factual issues that will have to be brought to the table to be able to determine whether or not the requirement of cause of work have been met for purposes of holding somebody liable or not. Of course, during the lockdown, for instance, despite the fact that people were encouraged to work from home, there are some works that couldn't just happen, except those few moments where courts deliver judgments and so on, in which event it was just the judge and maybe one person. The other members of staff were really not involved. So let's assume something happens to any of them. Can you really say it was in the course of work when he was actually not doing anything? For the judge who was reading the judgment, for the clerk who was there to support the judge in doing a virtual hearing, okay, yes, we can say this is now a new form of work, and consequently the definition of in the course of employment covers it. Again, these are the kind of things I always say that yes, because law must be understood in context. We must be able to look at the context and ascertain whether, yes, we can extend the rules to include or we cannot. Nobody is going to give you a hard and fast answer right now. The only thing you are going to get are assumptions, possible answers, until we have live cases and peculiar facts relating to the injury, the person in concern, the place of work, the nature of work itself. Until we have all of that on the table, is going to be very difficult to give you any hard and fast answer.
And I think I'll take this to be the last, because I know we're again out of time. How does the judiciary determine employees of agencies that qualify as public officers? I mean, how does the NICN treat employees of agencies that qualify as public officers? Sometimes the NICN owes that employees of CBN or NDIC are not public officers. This becomes confusing, especially since the employees of these organizations have been held and known to be public officers. Has anything changed in relation to their categorization? I mean, the only thing that is not stated there, which I think we often run into, would be either in relation to the computation of the time VAR for bringing an action against public officers, and/or garniship proceedings, where arguments have been made that there's a need to obtain governor's consent.
I don't know whether you're bringing that in the context of recent decisions where governors are asked to vacate for leaving us. But I want to read, you see, I don't know. I want to read the constitutional provision. The Constitution did not define public officer.
Okay.
I think the closest was public officer for purposes of the Code of Conduct under, just a minute, what schedule makes provision for Code of Conduct? I think it's the 5th schedule. And then it says, without prejudice to the generality of the foregoing paragraph, a public officer shall not, then X, Y, Z. It goes ahead. Let me see whether it defines public officer. Then in paragraph 19 says public officer means a person holding any of the offices specified in part 2 of this schedule. And then part 2 of this schedule, public officers for purposes of the Code of Conduct: President, Vice President, President and Deputy of Senate, Deputy Speaker and Speaker, Governors and Deputy, Chief Justice, Justices, President, Court of Appeal, and all judicial officers and all staff of court law, Attorney General. What point am I trying to make? Attorney General is defined as, is also. What point am I trying to make? The 5th schedule is the only schedule in the provision in the Constitution that defines public officer. And you and I know that definition is restricted for purposes of only Code of Conduct. So, for other purposes, the Constitution did not define public officer, but it defined what it calls public service of the Federation. And let me read it out. Public service of the Federation means the service of the Federation in any capacity, in respect of the government of the Federation, and includes service as. What do you understand by the word includes? Includes means this is just enumerative. It's not conclusive. So the main thing to be interpreted here is service of the federation in any capacity. If you go to the definition of civil service, it says service in the government in the civil service. It uses the word civil. Let me look for civil service. Civil service of the federation means service of the federation in a civil capacity. In a civil capacity as staff of the office of the president, vice president, ministry, department of government of the federation assigned with the responsibility of any business of the federation. Now, compare that with public service of the federation. It says service of the federation in any capacity. Civil service is restricted to civil capacity. Public service, any capacity. The question you will have to ask yourself, whatever office is in question, is service in that office service in a capacity in respect of the government of the federation? If you can find the answer to that, then you have the answer to whatever question is before you. Every other thing listed there are enumerative because the word includes is used.
My Lord, so it leads me to a related question. Time was when the industrial court took the view that the Public Officers Protection Act would apply to contracts of employment. So, I mean, if an employee fails to bring an action within 3 months, I mean, there are a couple of cases where the industrial court had summarily determined that the action was statute bar, was time bar. In the last few years, and relying on the Supreme Court's decision, the industrial court has overwhelmingly now held that it will not apply to contracts of employment. That is, the provision or anything relating to limitation of action will not apply generally. Now, the question has also been asked that the decision under reference, it just skipped me now, and I know my Lord will come to this.
There's Ajibola, there is
this Ajibola. That's a mass development, Ajibola. That Ajibola, which Justice Ariwola gave the leading judgment, related to POPA. It was specific that decision was made in the context of applicability of limitation, I mean, the right to bring an action.
He spoke of POPA, but he also mentioned limitation law. He also mentioned limitation law.
So, my Lord, the position...
He talked of POPA as limitation law.
An example of POPA as limitation law. So the position now is an action, for example, that is brought forward to make a claim for, let's say, unlawful, wrongful termination 5 or 10 years after the cause of action in itself arose. Would the courts not perhaps intervene to say that action is caught by time because it relates to contract and it was brought 6 years beyond the time, knowing fully well that there's a philosophy behind not congesting the courts with stale claims? So there's a competing jurisprudence on the one hand that let's enable this aggrieved employee brings his employee.
Yes. There's a principle in labor law. If an employer spends too long a time in disciplining an employee, he is deemed to have waived or condoned it. Now, if an employee waits 5, 6, 7, 8 years, 10, he was dismissed and then decides to wake up today, why limitation law? Why not laches and acquiescence? You see, for me, again, my very good friend, Justice Afen, talks of theory deficit.
Yeah.
And I think that's one of the things we have here. Now, let me go back jurisprudentially. What is limitation of action? Limitation of action is just a disability. I'm sure when you read jurisprudence, you were told of legal correlatives.
Yes.
Duty, right, duty, privilege, liability, disability, and so on. Limitation action is a disability. Now, I'll give you a simple example. Diplomatic immunity says you cannot go after certain diplomats. Let's assume you are knocked down by a foreign embassy car. You cannot sue the embassy because of diplomatic immunity. But if the embassy has an insurance company, you can go after the insurance company. In other words, the immunity enjoyed by the embassy disables you from pursuing a right against them. But it has nothing to do with jurisdiction. You see, we have confused this word jurisdiction. If you are disabled from pursuing a right, it does not mean that court does not have jurisdiction, because while you cannot go after the embassy, you can go after the insurance company that insures that car. If it is a Nigerian company, you can go after it. So you cannot be talking the court does not have jurisdiction. What happens is that the law has disabled you from going against the embassy, but you retain your ability to go against the insurance company. So strictly speaking, limitation of action is not about jurisdiction, it is about defense. But unfortunately, our case law is replete with this statement. Once it is statute bar, court does not have jurisdiction. Consequently, you dismiss the matter. When I was talking about confusion or trade dispute, inter and intra-union dispute, this is another area where we have confused it. Now, if limitation of action is an issue of defense, okay, the law says 3 months come. There are rules now that say, no, when it comes to employment rights. Don't forget, if you look at the history, it talks about contracts of works and services.
Absolutely.
Now, it tells you you can't go, because the truth of the matter is, let's be realistic with ourselves. If somebody is owing you salary for 10 years, shouldn't you be able to claim for it? By the same analogy, why should it be termination that you cannot claim? But the corollary is this: for disciplinary purposes, if the man stays 4 years without disciplining you, he cannot turn around tomorrow and say, I'm terminating you for something you did 4 years ago. The law says you are deemed to have condoned it. In the same logic, if you stay in your house for 6 years and refuse to contest a termination, how can you come today and be talking that you want to sue for termination, when the issue should be whether you have not waived your right, whether you have not condoned by accepting the termination? For me, again, I go back to what Judge Zafen calls theory deficit. We hardly take these things into account. We hardly look at these things in context. And when we come, we are happy to just lay our hands on a case that says something that looks nice for us. We grapple it, come to court and cite it, and beat our chests. We've done our job for today. We wait for the court to. And of course, those of us who write judgments, again, there are so many judgments to write. So why should I worry about being very detailed about a particular issue? Why should I worry about making all the research? If you go to an average judge now, there are 1,001 judgments he has to write. He does not have time to be making fine distinctions that you are making. So this thing is just a combination of problems that have crystallized over time. And for us, we need to begin to those who can, to begin to, well, we are doing it. It's part of the interrogation we are doing now. Hopefully tomorrow, somebody will be more astute, will be more resolved. No, this thing is not so much about this, but the man, 6 years, he didn't contest. There are rules that say, look, if you fail to act, equity helps the vigilant, they say, not the indolent. You waited 6 years. The question is, for God's sake, why shouldn't we assume that you have, what do you call it? You have condoned it. Of course, if there are explanatory circumstances, take for instance, those cases where you are facing a criminal trial.
Yes.
And you are waiting for the outcome before you know whether you have a civil right. Those ones are understandable. You can explain. I stayed 6 years without coming because it was only yesterday I got a reprieve from the Court of Appeal saying I'm not guilty. So you can come back and but where you did nothing, and there are even Court of Appeal decisions I have seen where it says if you are terminated and you collect the terminal benefit, you should be interpreted as having accepted the termination. So if within this period, I have seen somebody, I think I have seen a case where within the intervening period, the man has started collecting pension. Then he turned around and came and said he wants to contest termination. But again, I've seen, I think it's a Supreme Court decision I have seen that says the fact that the man was paid terminal benefits does not take away his right. Particularly if you look at circumstances of today where you are sacked today and the following day your account is credited. And there are some banks that if you write to them and say, look, reverse this, they tell you we cannot. So in circumstances like that, the question is, how soon thereafter did you complain? I have done a case where the person said, what they paid me was not what I'm entitled to. And I said, where's your evidence? He said, the document they brought for me to sign, which says I am collecting this thing in full and final payment. I endorse behind my signature that this is not all that I'm entitled to. I held that to be a valid protest and said, yes, if he proves that what was paid to him is not the full, he can claim the balance because he signed under protest. Some of these things we must learn to do. Nobody is holding your hand. If you carry your hand and you sign in full and final settlement without indicating that, look, you are taking this as part payment. Of course, if it comes for interpretation, as far as we are concerned, you have signed out your right. But if you indicate that, no, I am signing under protest because this is not my entitlement, all of my entitlement, we will tell you, go ahead and prove the balance, if you can, or what is outstanding.
My Lord, I'm sorry to just butt in the right there, and I hear that, and it's a fact scenario that I've actually had to contemplate at a point. Yes, indeed, I know there are a couple of cases from the industrial court on that point. That if he signs under protest, I think it was a court's first variance case that
was the first one. Yeah,
that was the first one. I remember that very well. But now, taking it a step further and then bringing it within the context of a contractual principle. This is the scenario. The employer holds the employee maybe arrears of salary for about 3 months. For 3 months, he hasn't been paid for 3 months. And he says, okay, I'll pay you just 1 month as full and final. So you sign. My Lord, most times the employees, if he signs and writes or indicate that he's signing under protest, he won't get that 1 month. So the uneven bargaining power comes into focus at that point. If that scenario comes up and he signs for 1 month without indicating that he's signing under protest, he subsequently sues in court for the remaining 2 months.
He won't get it.
I would imagine he won't get it. My Lord,
he won't get it.
My Lord, this is where I disagree, and I think I can just give it.
You have to be courageous to sign
My
under
Lord,
protest.
he will not get it. And I think this is where the industrial
court. No, but if he does not get it, he comes to court.
Okay, my Lord.
If he does not get it, he comes to court. Then the court will look at it. If he's entitled to it, the court will give him all. Don't forget, he collected 1 month and is coming to court for 2 months.
Yes.
He can as well come to court for the 3 months.
My Lord, in local context, you say you don't use good money to chase bad money. So the man is economically disadvantaged and it needs urgently to get that 1 month. My Lord, stretching it a bit further, and I think this is a principle that I think has not been perhaps put forward in any of the cases I've read from the industrial court. There's something called the rule in Pinel's case, which I think our Supreme Court has equally now agreed to. That scenario falls in within a rule in Pinel's case. He is entitled to 3 months and is being asked to sign off 1 month. He didn't provide, the employer did not provide a consideration. So that's a unilateral contract. And I would have imagined that even without him indicating underneath, the industrial court can as well treat it as a situation that falls in as a rule in Pinel's case, which is an English case, and the Supreme Court has actually applied that if someone within that category, economical disadvantage, is being made to make a new contract, because that is really what it turns on, it will be interpreted to be a unilateral contract to the extent that the counterpart has not provided a consideration for him to accept 1 month. He's entitled to 3 months. That is what is entitled to in the contract. And just to get 1 month, he's asked to sign off 1 month. He's asked to sign off 1 month. And he cannot come to court to ask for the other 2 years.
The contract law that I read also says forbearance to sue is good consideration.
And that's why we are saying that at every point in time, it is the uneven bargaining power.
That's what I said. The contract law I read says forbearance to sue is good consideration. First, we don't know the circumstances in which the employer says sign this.
Yes.
It may be to let him off the hook on something.
Yes.
It may be. I'm not denying about the rule in Pinel's case. I'm not denying that at all. But like I said, there are facts that are not available. It's based on what you asked that I'm answering. Of course, if details of other facts come in, of course, we'll then know whether there is an exception to the rule in Pinel's case or not that will be applied. But the point I'm trying to make is this. The man comes to you and says, sign. Nothing stops you saying, but this is not all that I'm entitled to. And it allows you validly to come to court and say, look, I want the balance. Now, if they say sign, because maybe you are under investigation, or don't forget, if he comes now and says, please give me this, I'm rushing to, like, of course, depending on how you interpret it, whether it is economic duress or something. Yes. The man is signing and say, look, I need to go and take another job. Like, if you look at the political sphere now, I remembered if they are replacing a deputy governor, for instance, and the governor chooses somebody who is a lecturer, the law is that he must resign.
Yes.
Before he can be considered for this. Now, he goes to his employer, the vice chancellor, and that one says, look, the best way for you to go is pay 2-3 months in lieu and something. He said, look, and then they talk and talk, look, just sign this thing. So a lot of these things do happen. There are underlying facts that sometimes don't come to the fore, which influence why these decisions are taken.
Yes.
So that's why I said forbearance to sue is also good consideration. You don't know what was given up for purposes of that.
Yes. No, my Lord, I speak the minds of those who are in, the participants, that it's been a very lively a reading session. Lord, if I'm allowed to just read a few comments from the commenting box, it's been insightful, illuminating, great exposition, and then the adjectives go on and on and on. My Lord, I will leave that to the DG of the ICLE to give the appropriate time. I'll leave the final question, which is increasingly we are all aware, and then we're talking about the work of the industrial court as well. So this is also quite important to look into, especially with a view towards deepening the jurisprudence at every point in time. And that is the issue of conflicting decisions, or what happens to be a conflicting position of the court. In concern has been raised about that. I think, for example, a question has been asked that training board, restrictive covenant, there are decisions from the industrial courts that on the fact analysis before the court had held that the employer would not be able to enforce the content of a training board as against an exiting employee. Ditto with a restrictive covenant in the, and on the other hand, there are a few decisions that all seem to say that, well, I mean, within the context of, if it is reasonable, it will be held to be one that the employer can enforce as against the employee, which will benefit, again, drawing from the principle of contract that, I mean, you don't benefit from a contract and to turn around months later to say it's tainted by illegality or anything of that nature. Now, the question, my lord, is that what is the industrial court's position, thoughts on this, and then what is the industrial court doing to extent ensure that the decisions, they all seem to reflect or take the shape and color of certain position that you can almost advise a client, or you can almost talk about that, okay, go to the industrial court, this is what the industrial court is very likely to say. Thank you, madam. And that will be all. And I'll hand over to Tobin.
I must apologize in advance.
Yes, ma'am.
When you have 31, 32 judges, it's very difficult that they will ever agree on an issue in the same manner. There are things we do in the background as much as possible to see how we refrain from giving what seems like conflicting decisions. We encourage ourselves to ask questions. Even myself, I call my colleagues on this issue. What's your view? Have you done a case on this area? And when I read the case and I notice there's something missing, I call the colleague, look, you did this, but you didn't consider this. And the colleague is like, yes, I didn't. Then I'm going to use it as a distinguishing point between my case and your own. So we do all of that to try as much as possible to reduce to the barest minimum the instances of conflicting decisions. I saw one of the questions relating to something about international best practices, and I know that is one area where supposedly they have seen conflicted, particularly in the application of international best practices in relation to particularly Convention 158 dealing with termination. That's a convention that has not been ratified by Nigeria, but it is a convention that evidences good practice. Now, if you want to rely on it, for instance, nothing stops you pleading it and proving it. The idea about pleading and proving is to allow the defendant the opportunity to disprove it. That's the idea. So if somebody relies on Convention 58, he pleads it, he proves it, and the judge decides that, okay, Convention 158 is evidence of good practice, and I agree with submissions of the claimant, but not the defendant, and applies it, he would have kept to terms with the mandate, which is application of good international practice. In other words, Convention 158 is not being applied as a convention that was ratified. It's been applied as evidence of good practice. In some of our decisions, when you read a judgment, sometimes it is not clear from the judgment whether certain things were pleaded or not. You may need to go to the file and take the pleadings to be able to check specifically. So I have seen some of those decisions, and I have spoken to some of my colleagues. I say, look, on this decision that you applied Convention 158, if I were the one doing it, I would have done something differently and achieved the same purpose. So we talk to ourselves as much as possible to reduce instances of conflicting decisions, but I can't speak publicly here and promise you that there will be no conflicting decisions, because then it means we superimpose decisions on one another, and which is not the point. Everybody is independent. Each judge is independent-minded. Each judge applies the law as he understands it, And now that there is a right of appeal to the Court of Appeal, the whole idea is for, in quote, these conflicting decisions to be resolved at the level of the Court of Appeal. But I'm sure if you compare NIC with other courts, ours is really, really, really minimal when it comes to the issue of conflicting judgments.
Thank you very much. Just before I thank my Lord, I'd like to make a few comments. So first is to say that there were a lot of comments regarding the time slot for today's session. And I think because of how interesting the session has been, the complaints had to come in. It had to do with the fact that a lot of our Muslim colleagues would be attending the mosque around about this time. We apologize for this situation. It wasn't something we truly averted our minds to at the time, but we generally try not to have our trainings on Friday. The recordings of this session will be circulated by email to all members of the association. And of course, I want you to know that the recordings of all the sessions by the MBA Institute of Continuing Education is available for all to view on our YouTube and the MBA's YouTube channel. It's interesting to note that and ordinarily when I look at the comments box and I see people saying I'm from this branch, I'm from that branch, I think it's a bit of a distraction. But today I found it quite illuminating and I think my Lord would like to know that we had participants from as far-flung places as Ethiopia, Omoko, Kaduna, Begema, Ikeja, Calabar, Ota, Ikote Mene, Banawa, Uheli, Makodi, and so on and so forth. So I'm sure you probably have had over 99 branches of the MBA participating today. And the truth of it is time moves very quickly when you're having fun, but every good thing must come to an end is the rule of life. People are calling for more time even today, but I think we must be considerate of my Lord, who has given more than I think God has given him even today. But thank you very much. So now I'll just thank Folabi Kuti, my brother, senior advocate. I think you made it more interesting. The chemistry and synergy between you and my Lord is something that's well known to some of us. And I think you brought out the best from my Lord. Thank you very much.
Thank you so much.
My Lord, we invited you to deliver a session on unemployment law. What I found is that today we've gone on a journey, on a jurisprudential and legal journey. Very interesting intercourse between thought, went down to Donahue and Stevenson, Rylance and Fletcher, bringing back many things. You also took us to the area of contracts. We also taught on administrative law. We also taught on consumer protection, and so on and so forth. I mean, I think it is only fair for me to say that Nigeria is a great country with great people. To find a judge with such scholarly intellect, because what you've done is actually to analyze every principle that has been raised, especially during question time. We're very proud of you, my Lord. We're extremely grateful. It's been a delightful afternoon. And the only thing I can say is that I am sure there will be a huge demand for you to come back. And we will indeed ask you, I will ask the employment law group to speak to you about a convenient time that we can have another session like this, probably on a topic of your own choosing, because I find that this has been very engaging and illuminating. And of course, as Folabi said, the adjectives are not ending. Thank you very much, my Lord. Thank you. We're very grateful. Thank you.
Thank you for thanking me.
Thank you. So we'll now move to the next session. And I hope people stay on. I know the attention span for this kind of sessions, webinars, is usually 1 hour, 30 minutes or 2 hours, but we still have over 1,000 people logged in. So that's amazing. I will now move to the next session for the afternoon. And I'll be introducing Mr. Osana Maubeku. Osana Maubeku is a partner with the Law Crest LLP, where he heads the employment law, HR and immigration practice team. After bagging his law degree from the University of Nigeria, Nsukka, He was called to the Nigerian bar in 2001. Osanoma has a master's degree in employment law and international labor standards, and also holds another master's degree in human resource management, both from the University of South Wales. Prior to joining the Lawcrest LLP, he worked for one of the top 4 retailers in the United Kingdom as a senior human resource executive and head of recruitment projects. He's a Prince 2 project practitioner, a member of the CIPD, and the chairman of the MBA SBL Employment and Industrial Relations Committee. He regularly consults for multinationals, private organizations, and government. He has led the HR integration process of significant mergers and acquisitions in the energy, finance, and FMCG sectors. He is regularly engaged by multinationals to assist in reviewing their entire HR policies and procedures, as well as developing functional employee engagement frameworks. He has presented papers on employment law issues, both within and outside Nigeria. He recently consulted for several governments on the recruitment and management of Nigerian medical personnel in diaspora, and regularly provides immigration advisory services for organizations as well as for individuals seeking to take up employment or residence in Nigeria. More recently, he has been involved in developing alternative framework models for organizations, as well as carrying out safe work audit leading to development and implementation of policies addressing compulsory vaccination, bullying, harassment, accidents. etc. Osanoma is recognized as a leading employment law lawyer expert by Who Legal. It is my pleasure and indeed my honor to welcome my friend, brother, and partner, Mr. Osanoma Opeku, to make his presentation this afternoon. Ose, I'll just urge you to keep it as concise as possible because I think we've taken up a lot of time. Thank you.
Good afternoon, everyone, and I hope everyone can hear me. Thank you, Tobin. I almost not recognize myself through your introduction, but I guess it's me, so I'll just take it. My Lord, it was a pleasure listening to you as always, and I mean, it's always a difficult task or ask to speak after me, Lord, but I'll give it a try and see how it goes. But in the main, some of the issues I wanted to deal with, you've actually addressed it in your presentation. So like, yes, that makes my job somewhat easier. So I will just be a bit more concise. Just to share my screen. Just a minute. Right, okay. I hope everyone can see my screen. Milon, are you able to see my screen?
Yes, I am.
Oh, great stuff. Okay, I mean, the presentation outline is as simple as this, just the learning outcomes, introduction, and questions and answers. But I doubt if there will be more questions or there will be time for that. But for me, at the end of the day, I think the idea is for people to be able to understand the dual application of our principal legislation, which is the Labour Act, which I'm sure Milord had actually touched on through a question that was asked. The specific effects and how in practice we've tried to overcome, quite apart from the being a minimum standard act and the way that the National Industrial Code approaches it in terms of interpretation, how we in practice have tried to work around some of these issues in advising our clients. So instead of going through a brief history of Nigerian labor law, Milord has gone through that, so I won't take time to go through that. But we'll just look at the dual application of the principal legislation in Nigeria, which in terms of labor law, which is the Labour Act. And obviously, we know that the Labour Act clearly defines a worker. And so by implication of not defining non-worker, what is not defined as a worker, we then take as non-workers. So section 91, the application section actually defines worker. And in defining a worker, it could be anyone who has entered into an employment relationship, either orally. So there's the worker, there's the oral and written contract, and who performs a manual or clerical task, but excludes those who perform executive functions, administrative or technical functions. So if you use the general rule of interpretation of expresso unus est exclusio, which the mention of one specific thing to the exclusion of the other means that the others is not covered, you would then say that the labor law, Labor Act as it is today, only applies to those defined as workers, specifically under Section 91 of the Labor Act. But having said that, we also make a point, which is what I made down below, that the Labor Act as it is a minimum standard act. And the law is also of that view, as I mentioned earlier. And so it can be used as a benchmark to then determine what would happen in the absence of any provision regarding to non-workers, or those called non-workers. And so what really are the implications of that? So question is it that the Labor Act is not applicable to non-workers? I mean, so I've spoken about recourse to, in approaching this, I've spoken about recourse to rules of interpretation. But in doing that, where the Act actually makes a general provision to say where a person or a party to this contract, then it has a general application. So you can apply that to everyone, regardless of whether they are known as a worker or not, because it's then the rule of general, is not a provision of general application. I mean, there are several reasons, albeit not clearly stated anywhere, why this could have, the process of the Labor Act could have been directed at just workers. We can look at the history of labor and work in Nigeria being one of the tailgates of our colonial heritage. And so if at that time, a lot of workers being very low education and poorly qualified were actually in what you would call subnormal workforce, in terms of they were mostly in the factories and the rail, working on the value chain of the rail lines. And these were actually seen as vulnerable people to an extent. So most of the laws were created at that point to actually protect those that were seen to be vulnerable and could not actually defend or protect themselves individually or collectively to a very large extent. And then for the educated people who were a bit more educated prior to independence and all that, were most of them were in the civil service and they had their voice. And so perhaps the thinking was that the Labor Act would protect the more vulnerable people. And that's why junior workers per se are presumed as automatic members of unions if you look at Section 5.3 of the Labor Act. So there's the option, it said that they can opt out. They are automatically deemed to be members, but then they can opt out. Whereas for those who are saying under Schedule 2 of the Trade Unions Act, which mostly covers senior staff, they then have the option to opt in, as opposed to the junior workers who are automatically members of the union, but then have to opt out. So there are specific, I'll just go to some specific instances in the Labor Act where there's a mention of worker, and which means those sections per se would only apply to workers. So you have Section 7, talks of particulars of terms of employment. I will go further down into these sections. Section 10, which talks of transfer of employment. Section 13 talks about hours of work, and Section 20, redundancy. Therefore, non-workers, there are some sections that generally mentions the word persons or woman. So termination is actually any party to a contract, but again, in subsection 8 and 9 of Section 11, there's mention of worker. And so those particular subsections 8 and 9 would then apply strictly sensu to anyone defined as a worker under the Act. Under Section 54, maternity rights, it clearly says every woman. And so that applies to any woman. Unfortunately, it will apply to a man. And so, I mean, we all know that men don't give birth. Well, in this part of the client, men don't give birth. And so it would apply to a man. So those rights apply to every woman, whether a worker or an employee, so defined. Then night work, and then the offenses under Section 64. But I would just more or less dwell on some of this specific example and look at the practical implication on how, in practice, we'll try to go around some of these provisions. Very important is redundancy. And that is a recurring decimal in terms of employee engagement relations and industrial relations generally. And so in a workplace, there will always be downtime and redundancies. And I mean, redundancy is one of those situations that's involuntary, through no fault of the employer or the employee, and maybe business contracts, there's a general restructuring, there's financial struggles, and there are technological interruptions, and then the roles disappear. And it's important that we realize that it's not the person that is made redundant, but it's the role that's actually made redundant. So Section 20 actually makes elaborate provisions to protect the worker in the event of a redundancy. So, which would usually be that the employer should negotiate in good faith with the employee representatives or the workers' union. Now, the question then is, does this mean that those not covered by the term worker are not protected in the event of a redundancy situation in the organization? Well, if you then look at the issue of non-workers per se, so those who are not defined, who are not covered under the definition of worker, there are three ways in which practically you can try to protect them. One, through the terms and conditions of employment. So the handbook. Typically, what is more common these days, you would have a provision under the terms and conditions of employment, typically the handbook, clearly stating what redundancy payment will be. So it will be a case of, say, so for everyone who has worked for 2 years prior to this time, if there's a redundancy situation, you'll be entitled to 1 month's salary for every year of service completed. That is one way to deal with it. Another way, and which is very common these days, is actually through collective bargaining agreements. So most CBAs will have a redundancy term in it to say, right, if there's redundancy, the union has agreed that everybody will get X amount of money as redundancy pay for each year worked. Now, there's also a third way. If these terms are not captured in the handbook and there's no collective bargaining agreement, if it has happened that you've had a couple of redundancies in the past and you have taken a particular path in resolving or paying for the redundancy, then so those things are seen as trade and custom. If you can actually prove the consistency that, hold on, this happened in this year, this is what you did. You happened in this year, this is what you did. So at this time it has happened again, then we have come to expect, based on trade and practice and custom, that you will do this. Now, in doing that, we need to be very careful as well. So in unionized environments where there's a collective bargaining agreement and the scale of what you be paid is actually set out, what happens in practice is that regardless of what has been put in CBA, the union would still want to negotiate for additional pay. I mean, we don't have anything against this, and for various reasons they do this. One of the reasons they do this is, and from experience, a lot of unions would have a surcharge of 10% of whatever they negotiate for employees as a first line charge on payments to be made to the employees. That's one reason. So financial reason on one end. On the other end, there's this constant struggle by union for relevance. So they need to justify to the employees that, hold on, we'll have your back. And you, because you had us, that's why we could get this for you. So there's that constant struggle to show that they have value that they're adding, and then they also value their financial value to them as well. But what I would advise and always do is to think about leveraging on an out of a CBA payment or negotiation if the most payment called an ex gratia payment. So ex gratia is simply a discretionary payment, because what tends to happen if you then negotiate with the union and agree on a new scale of payment for redundancy, it becomes the new CBA term for redundancy, and they will always refer to that. But if you then have it as an ex gratia to the extent that, oh, this time we were able to find out some money somewhere and we're able to pay ex gratia, but it is not a constant, it's only done in this particular situation. So you can, next time it happens, still negotiate on the terms of the old CBA. And this is very, very key. And we see this every time there's an issue and we need to have some form of negotiation around redundancy. So the bigger issue, I mean, again, in terms of non-workers, what some employers also do is to, by contract, incorporate Section 20 of the Labor Act to say, oh, if there's a redundancy, the provisions of Section 20 would apply. I mean, it's fine, but the challenge lies in that there is no circumscribed time frame or standards for coming to terms of agreement for redundancy pay under Section 20. So it just says that the employer should negotiate, after information, negotiate with workers' union or representatives in good faith. So truly, what is good faith? And so with this way, the negotiations could drag and drag and drag and drag forever. And so just to put this in context, I'll give a practical example of a client who is no longer in business in Nigeria. So it's public knowledge, so we can actually share that, case study. So they had three strata of employees: the workers who were in the junior staff union of top, they had the senior staff union, and they had some other employees who were, by virtue of their position and being projection of management, could not be in the union. And so there was a case of final closure of the factory and went to negotiations. With the union, with the junior staff union, that was fine, that was sorted. There was a CBA in place, payment was made based on CBA. We agreed on some final takeaway as gratia with products from their factory. Same thing for the senior staff who were members of the union. Interestingly, a couple of years back, we had done an audit for the organization and advised that for this very senior executive who could not be members of the union, perhaps they should have a clause in the employment contracts so that their redundancy pay could be captured. And what this did for the organization, when we started off, they could actually capture the total expense they were going to make on redundancy for the whole factory. And that way it was easy to get a sign-off from their parent company. And so the senior executive were of the opinion that they were part of the senior staff union, but it was very clear that they were not part of the senior staff union. And so because this was very clearly set out, there was no argument about this. And then, I mean, it's one of the easiest redundancies we've had to do. And so it just shows how you can practically navigate some of these issues and make life easier for you when they do arise. And I think one of the most critical one, again, using the example of a section that applies to everyone, is Section 54 of the Labor Act, which is about maternity rights. I mean, this section applies to every woman, and it guarantees protection of employment during maternity, time off for breastfeeding, which is more or less converted to additional break time, 3 months maternity leave. I mean, this is something that should not be confused with maternity pay. So every woman who works in an organization, irrelevant of the time spent in that organization, is entitled to maternity leave of 3 months. However, to be entitled to maternity pay, that employee must have worked for at least 6 months. So there are two things. Maternity leave, no qualification. As long as you're a woman and you're an employee, you're entitled to maternity leave. Maternity pay, you must have worked for at least 6 months to be entitled to at least a minimum of 50% of your normal pay as maternity pay. And also, more importantly, you cannot terminate a woman who's on maternity leave. You cannot terminate her appointment or give her a notice of termination that would end during the period of her maternity. Or if she has a certificate to say that she's unable to return to work and is still within the time frame granted in terms of your sick policy and all that, you still cannot terminate her appointment. And this is a very strong protection for women who have just given birth. And it applies to every woman, not just to a worker. I make the point again. And just to reemphasize the difference between maternity leave and maternity pay. I mean, I've had an incident, going very practical again, a couple of years back, where a client had called and said, this lady's on maternity, we need to terminate her appointment. I was very clear and said, no, you cannot. And he turned around to say to me, but you said the Labour Act does not apply to non-workers, and she's not a non-worker. I then turned around to say, well, hold on, I did say to you that there's some sections that applies to everyone, and this is one of those sections. And I thought that was the end of it. I think about 2 months later, they come back to me to say, oh, she's back to work now. Can we then terminate her? I mean, there's a moral issue there, but technically, yes, they could at that point. But morally, was it justified? But thankfully, that never happened because there was a change of attitude and change of heart, and the young lady stayed until she left a couple of years later. Again, termination of appointment is another section that applies both ways. Certain provisions and subsections of that section applies generally to everyone. But section 8 and subsection 8 and 9 specifically mentions workers. So using that same rule, it would be that those, simply put, those particular subsections will only apply to those defined as workers under section 91 of the Labour Act. And one thing I always say in advising clients on labor law, it's very important that we keep an open mind, because, I mean, in practice, I do not think there's any area of law that has so much interactions of different statutes with the employment relation than the employment law. And so it might be that the question is an employment law question, but the solution to that might actually be in company law. We've seen that over and over again. And in that practical example, that matter is still in court today. So a couple of years back, a client came over and said, hold on, the board of directors have been paying themselves X amount of money. It was approved by the board and blah, blah, blah. I don't think they should be earning this. The company is not making money. They shouldn't be earning this. It's not fair. It's not morally right. But our first view was, hold on, but this is a contract that you all signed, and this is what has happened. They have the right to do this, and went on and on. But the client insisted. We went back. And interestingly, my partner, who is the chairman of the ICLE, turned around and said, come on, this is the director of a company. Does the company, does the directors, can they actually approve their remuneration? So we went back to the company to CAMA. And it was very clear that remuneration of directors will only be approved by shareholders at the annual general meeting. And so bingo, here we were. So that matter is still in court till date. And that's another thing. That's how to look at how other laws interact with the employment law. So if there's a query from a client on an aspect of employment law, it is critical and important that you sit back and think of any other act different from Labour Act or the standard employment law laws or statutes like the Pension Reform Act and all that, that would actually impact on that relationship, and then look at it to actually come to a very robust solution for your client. I mean, there are a whole bunch of laws. At last count, there were about 32 laws which impact on the employment relationship. Of course, we can't take all of them, but I've just signposted a couple that you must be very careful about. There's the Pension Reform Act. And the Pension Reform Act is quite clear to the extent that every person who works in Nigeria as an employee should contribute into the Pension Reform, into the Pension Act if the employer meets the criteria of numbers. So which is 15 or between 3 to 15, or the other person can then be on a micro pension scheme if you're self-employed. But the issue then is what happens to expatriates. I mean, on the face of it, if an expatriate takes a job in Nigeria, then they are working under a contract of employment in Nigeria. So automatically they should be opted into the pension reform scheme, the pension scheme. But in 2016, the Pension Commission came up with what they call guidelines for cross-border arrangements under the Pension Reform Act. This was issued in 2016. It then created a window for expatriates to actually opt into the pension scheme. But then the process of exiting is slightly different from the process of exiting for Nigerians. And that guidelines also created a situation where Nigerians who work in the diaspora can actually contribute into the scheme as well. So for expatriates, when they exit, within 3 months, they can take out everything they've contributed into the scheme, which is slightly different from Nigerians who have to take a lump sum and then do programmed withdrawals or an annuity. So these are some issues you need to actually look at again. Then another typical issue that comes out in pension is the case of unremitted pension contributions. And my friend Folabi was involved in one recently, but that's a topic for another day. So where an employer deducts pension from the employee but does not remit, what then happens? The Act is very clear that if after 6 months an employee does not provide, so in the case the employee does not provide an RSA account, if the employee does not provide after 6 months, then the employer has a duty under Section 11(5) to go to a PFA and open a retirement savings account for that employee and pay everything into that account and pay subsequently. I mean, the issue here in Falabi's case was that they deducted, right? Let's say they deducted, but they did not remit. The employee in question went to court challenging this, and National Industrial Code ruled that the money should be paid to the individual employee. I mean, I have my disagreement with that in the sense that if there's a clear provision under Section 11(5) and the intention of the Pension Act, what it's meant to actually, why it was set up, then it would have been the case that it would be to pay the money into an RSA. But that's another issue we intend to take up on a separate conversation, but I just thought to mention it. Now, we not have actually spoken about Employee Compensation Act. It's actually a no-blame act. So it's regardless of whether the employee was wrong or right, or the employer was wrong or right, or there was contributing negligence. Once the employer contributes to that fund, the employee then has a choice whether to claim under the fund or to make a claim in civil negligence. Now, I've mentioned the issue of karma earlier, so I won't even dwell on that. But another critical one is the FCPC Act. I mean, there's been issues and hue and cry and arguments about restrictive covenants and restraint of trade. What the FCPC Act has done under Section 68E, which will give statutory backing to restrictive covenant as long as it's no more than 2 years. I mean, depending on the sector, depending on the peculiarity of the circumstances, 6 months or 7 months can be held to be unenforceable. But by rule of thumb now, if you look at restrictive covenants, if it's more than 2 years, on the face of it, it is illegal based on this provision of the FCPC Act. I mean, this is something that a lot of nations we need to think about how to advise our clients on this, quite apart from the conditions of geographical spread and all that, but you need to look at the timing, the length of the restrictive covenant. There are a whole lot of other acts like the Social Trust Fund Act, Factories Act, National Minimum Wage Act, Trade Unions Act, HIV Discrimination Act. But as mentioned, I mean, if there's anything anybody should take away from this, with the climate that we are in now, in terms of employment law, the CEDAW as a Convention on Elimination of All Forms of Discrimination Against Women, Convention 190 on Violence and Harassment in the Workplace, which was actually ratified by Nigeria in 2019 when it was passed. And then Convention 158 on termination. These are three critical conventions that everyone that practices in this space should take time to study and understand, because it's either they are applied as law because they've been ratified, or they are applied as best practice. And again, to apply it as best practice, you need to plead it and you need to prove it. And the only way to do that properly is to actually understand it. So for anyone that practices in this space or will have to advise clients on these issues, I think it's important that you have a very good understanding of CEDAW, Convention 190 and Convention 158. And if it's necessary, we are happy to send out copies to the ICLE to everyone to have a look at it as well. I mean, I will just also mention the DPRO guidelines on release of staff in the oil and gas industry. So for those who advise clients in the oil and gas industry, there's another level of check that has to be gone. So to terminate someone in oil and gas industry who's a Nigerian employee, there's the need to get the consent. It's just like the ministerial consent for transfer of assets, to get the DPR consent for the employee to be released. And so these are typical scenarios that you face on a daily basis, and just basic practical means to get around them. But again, I make the point that it's important, with the way the National Industrial Code is moving, very, very, very progressive minded and up to date. So it's important for us that practice in this space to also catch up and be up to date, if not faster than them, to be able to deal with some of these issues and to advise our clients properly. I think that's me done now, and I'm happy to take on questions if there are any. Thank you very much for the time.
Thank you very much, Jose. Falabi, are you still there?
Yes. Yes, okay. Yes. See very much. I mean, listening to Jose, beautiful presentation and quite lucid on many fronts, and then has addressed quite a number of things that I think are very topical in relation to the subject matter. So I'm still very much here. Thank you so much.
It's almost 4 o'clock. Time is fast spent. I think what we'll do is actually to try and capture all the questions that were asked, that have been asked throughout the session, and see whether we can get my Lord to answer those ones that concern him. Absolutely. And then perhaps 3 or 4 questions for Jose, then we round off, and then get an undertaking from him to respond to the ones.
Yes, I agree. I agree.
Thanks, Falabi. Over to you.
Yes, yes. Okay. Struggling with oh, sorry, my video. There's a small challenge, but I can just continue. Also, very much, thank you very much for what a colleague has commented to be short, sharp, and sweet. Short, sharp, and sweet. So you did the 3 heads within a very short time. A rather beautiful presentation, quite lucid on many fronts, like I said. At this point, I'll go into the comment box. Okay, I raised a few questions there. One, someone has asked that, what is the woman whose employment is terminated during the period of maternity leave entitled to? Will she be reinstated even in master-servant relationship? Can she get damages other than salary in lieu? and all that. But before you answer that, I just thought to provide additional context to the reference to the particular case law on pensions that you addressed that I was involved in. Yes, what had happened there was a very unique situation of having to make the industrial court to examine a scenario where a former employee, a foreigner, had resigned and traveled abroad and has come back to make claim in relation to pensions that were not remitted, for which, by his contract of employment, when the employment subsisted, he was obliged to give an indication or indicate to the employer that this is the administrator that he would have loved for the pensions to be remitted to, but that was not done. So post-employment, the question that came up is, should it be paid over to him? And we took the view that in light of a number of the decisions from the same industrial court, I mean, in the context of explaining the philosophy behind pensions, that unless certain thresholds were in place, pension was never to be paid over to the employee, but rather to go to, and in light of even the Pension Reform Act, but should be paid through the fund administrator or should be paid there and all that. And how that unique situation should be dealt with in the case of a foreigner, and it was a situation that arose post-employment. And in that case, the court took the view that it should be paid over to him. And that was really what happened there. Very quickly also, you made mention of this law that as part of the laws to look into the DPR's guideline. We are quite aware now that the industrial court, in some revolutionary decision made last year, has actually held that will not apply to restrain or to make those within that particular sector comply with before they can take a disciplinary measure of bringing unemployment to an end for employees within that sector. And there are still a few strands of decision and strands of cases in court still on the point. It will be interesting to see how that will pan out and all that. So, I mean, that's my own additional comment. For now, Jose, I'm sure you're ready to take that question. And whilst at that, you may also want to look into what your advice would be with, there was a question that was asked, and I'm just trying to pull it up now, that has to do with, okay, I mean, he wanted you to still expand on, wanted you to kindly expand on the regulation on termination of an employee in the oil and gas industry. Yes. So, can an employee employed via an employment letter be terminated orally? So, an employee employed via an employment letter, can it be terminated orally? And the specific question relating to maternity leave. So over to you.
So I think I'll start with the oral termination. But if you think about it, in almost every employment contract, it will clearly state that a 30 days notice in writing or salary in lieu of notice, right? So the standard would be that your termination will be by writing. However, if you're terminated orally and you accept that you've been terminated and take the termination pay, then for all intents and purposes that has happened. But in real sense of it, if you say to me, my contract says 30 days termination notice in writing, that's what it ought to be. On the issue of what the level of the volume of damages to be gotten for an employee who is terminated while she's on maternity leave. I mean, it's a statutory provision that you cannot terminate while the person is on maternity leave. If you then get terminated, what is the quantum of damages? Again, that would depend on the state of plea. What are you asking for? Are you asking for special damages or general damages? What would that entail? What can you actually prove? What have you actually suffered? And it goes all and all into that. But interestingly, now that Milord is here, I would also love to hear his view on this. because I mean, the issue of damages in national industrial code is another issue. Another kettle of fish that we'll have to sit down and have a conversation about, and how some of these damages are arrived at. And so because he's here, I will defer to him. I will let him have a bite on this, because I mean, he's here. So maybe he can just give us his own take on that as well.
I absolutely agree with you. So over to my Lord. My Lord, we are sorry to bring my Lord back.
What's the question again?
It has to do with the quantum of for whose employment has been brought to an end. On well, I mean, the question has not been taxed that, but I would imagine in the event of pleadings, that is really what you will basically be pleading. Discrimination on account of sex, gender. Yes.
You terminate on pregnancy.
Yes, pregnancy.
There's a particular case my predecessor did.
Yes.
I think that was the first.
Omeka's case.
He awarded 2 years salary.
Yes.
I think he said something about reinstatement was not asked, so he didn't order
reinstatement. Yeah.
But I want to believe that if reinstatement is requested, I want to believe that it will be granted. Of course, it depends on the strength of the proof by the counsel involved. But in terms of damages, the available authority on the subject so far gave 2 years salary as compensation.
And what brings us to a related question. Restatements in master-servant relationship.
Yes.
Restatement in master-servant relationship.
Let me start from the known to the unknown.
Unwilling employee or the employer to accommodate a willing employee.
Let me start with the known.
Yes, ma'am.
The regular courts acknowledge that statutory employment, you can order reinstatement.
Yes.
Even at that era, if you came to NIC and you could prove that you were terminated because of union activities.
Yes, yes.
You also
absolutely.
interpreted that because if you go to section 42 or 43 of the Trade Disputes Act, it disallows an employer from locking out workers who are on strike. So we use that provision to say, if you don't have authority to lock out, it means if you lock out, it's null and void, and it goes against a statutory provision. So we held we could order your reinstatement.
Yes.
That's the known point number 2. Then came third alteration. Third alteration says we can apply international best practice. I saw one of the questions. Why is it that we apply Convention 158 when it is not ratified? Like I said, if Convention 158 is pleaded, it says you must give a reason before you terminate. If Convention 158 is pleaded, and in the circumstances of the case, it is accepted as good practice. In other words, the employer did not tell you why he's terminating. Again, I go to known point 3. We have held that in the banking sector, because of the sensitivity of the banking sector, you cannot treat termination in the banking sector just like you treat in other sectors. For the simple reason that whoever is terminated in the banking sector will never get a job in the financial sector again. So, on that ground, the case we started off with held that such a person, apart from a verdict that the termination is unlawful and is null and void and all that, will get aggravated damages. But subsequent to that, some of my colleagues have specifically ordered for reinstatement. I know 1 or 2 that are before the Court of Appeal, so we'll have to wait for the verdict of the Court of Appeal. Now, to the question whether there is a general right of reinstatement other than this, My answer is depending on the proof. There's a case my colleague did, and the storyline was this man was sent to a particular unit or branch of the bank, and he started discovering what looked like untoward practices. He raised alarm, and because he raised alarm, according to the story, they were not happy with it and decided to lay him off. He then came to court. My colleague applied Convention 158 and reinstated him, I think, or something of the sort. And I said, if I were the one, I would have used a different option. And what is that option? We have a policy right now that is fighting corruption. Now, if you transfer me to a unit where I am beginning to unearth corrupt practices, I demand to be patted and rewarded, not terminated. So if you terminate, we have decisions we have made where we said, you cannot suspend, you cannot terminate a whistleblower because he's engaged in the fight against corruption, which is a wider policy to be pursued by all in Nigeria, including the courts. So if I were the one, on the grounds that you terminated him for fighting corruption, and fighting corruption is a value system pursued by all in this government, I will use that to reinstate the person. Let the Court of Appeal say, I am wrong. Let the world say, because I reinstated you for fighting corruption, I am wrong. So it depends on, like I said, the facts of the case, how it was argued, and what was presented before it. That particular case, if I were the one, I won't be talking about Convention 158 at all. I'll be talking about the greater value of fighting corruption. Why there's a necessity to encourage, because if I encourage an employer to sack you for fighting corruption, it means I am not helping the cause of fighting corruption. So that would have been how I would have treated it if the matter were before me. But like I said, the matter had been decided. I think they're in the Court of Appeal. I don't know what they are going to argue there and how it will come.
Yes. Indeed, very much, my lord. I recall the one involving the bossa of Yabatek that my lord decided along that line on whistleblowing, and who was terminated in the course of the matter that was still pending in court, and the court ordered as part of the relief and the fact that it could be restated. Thank you very much, my lord.
It's like,
okay.
It's like sacking me because I came to court. As a judge, do I promote that as a value system? In other words, do I tell an employer, well done for sacking somebody because he went to court? So some of these things I agree, I admit of some value judgment, some value thinking. But the truth of the matter is that we ought to be able to ascertain the values we want to uphold, the values we want to encourage. Some values are higher than others, no doubt. And for me, if you bring a matter, I'm sorry I'm saying it, maybe tomorrow when the matter comes, they will say I have spoken publicly. I should recluse myself. But if such a matter comes, for me, the value of safeguarding the right to go to court, in fact, I have held that one where I held suspension and denial of promotion as being vindictive because it was done on the grounds that the person went to court or the family of the person went to court. I felt that that is not a value system to encourage. You cannot punish me because I went to court or my family went to court. That one, at least there is authority that I have done it. But on the question of fighting corruption, of course, there are authority. We said whistleblowing should not be an item for which you should be suspended or for which you should be terminated. In the same vein, if you do something, of course, I'm talking here on the basis that it is correct. I'm not saying those who whistleblow simply because they want to get at somebody. In other words, there's nothing inside there, but they are just doing it to get back. No. I'm talking of where there's actual valid whistleblowing.
Whistleblowing, yes.
So we must agree as a court as a judicial system, the values we want to chase.
My Lord, in addition to that, I mean, and somebody just made an instructive comment in relation to the employee, the master-servant relationship that's been ordered to be reinstated back into the work of that unwilling employer, that maybe as an additional consequential relief, because you'd always had police protection too. And I'm quoting the comment now, because his life may be at risk. And I agree that's the practical.
There are you and I, SN, you and I know that a court does not make an order in vain, and a court does not make an order that requires policing. It's one of the rules in terms of remedies that courts give.
Correct, my lord. Correct, my lord. Yeah. Because once he's back at that work, he'll be working on eggshell. He's been sent out, and the court has ordered him back. He's in trouble.
Situation.
Yes.
I am very sure the judge will think of the relationship, and would prefer aggravated damages over and above reinstatement.
Reinstatement, absolutely.
I am sure they will prefer, because if reinstating you in any event, there are Supreme Court decisions which held, for instance, that an employee who gives notice of retirement to retire in 3 months' time can be dismissed before the expiration of the 3 months if he does something warranting dismissal.
Yeah.
There is a Supreme Court decision on that. Yeah. So if I am the one who is being reinstated, I also need to think I can be reinstated today, framed up for another charge tomorrow, and sacked.
Yeah.
The fact that you are reinstated does not mean you have immunity. That's something we must understand. So all of these factors must play in the minds of the judge in deciding which appropriate remedy to give. Sometimes when you see a judge refusing to reinstate, it's not so much that he cannot reinstate, but sometimes he has weighed the options and discovered that reinstatement may just be a trap for the person.
Yes.
You can go into the system. I have seen the case that learned SN Folabi mentioned. It might interest you to note, it was, I think, on 1st July 2015. The matter before me was against his suspension. The day I was reading the judgment was the day he was terminated. While I was reading the judgment, holding his suspension was invalid, they issued him a letter of termination. Now, assuming they waited 1 day, and I said the termination is invalid, they recalled him and for another reason sacked him tomorrow. Of course, he cannot come back and say it is because of the suspension or the judgment.
Mm-hmm.
Because a judgment does not give you immunity. You cannot claim immunity. Simply because you got a judgment does not mean if you commit an infraction, you cannot be disciplined on that new infraction. So the judgment doesn't give you immunity. So sometimes the judge looks at all the facts. He looks at sometimes even how they comported themselves in court. Like if you notice there's a measure of bad blood between them, you come to the conclusion that no, these two cannot just cohabit.
Yeah.
So that weighs in determining the remedy. The man's wants reinstatement, you say, no, I can't grant it. Because deep within you, you know that if you give him reinstatement, you are entrapping him.
No, or he will be back in court soon for constructive dismissal.
Yeah,
most likely.
Yes. I mean, Folabi, I was going to make a point, my Lord, and this is something that's come up almost every other day. I mean, as in, so, and I think you've answered the question, that's always my view. If an employee has handed in a letter of termination, a notice of termination, and subsequently there's something does an infraction with the employer, dismissed. Absolutely.
The only thing is, if the notice of termination is immediate,
yes, absolutely,
then he leaves immediately. Anything you do is after the effect, and that's not like
absolutely.
But if he gave you 1 month's notice,
and it's still working,
April, and he tells you, I give you 1 month's notice, I'll be leaving by 1st or 2nd of May next month, and the man doesn't show up in work tomorrow, you can sack him for absconding.
Absolutely, absolutely. That's right on the money, absolutely. We're on mute.
Thank you so much, my lord. Also, two quick questions. When the contract requires 2 weeks notice by both parties,
Yes.
I'm reading, the employer can pay 2 weeks notice. The employer can pay salary in lieu of the notice without due process. Okay. Sorry, I mean, I'm just trying to make it out. When the contract requires 2 weeks notice, I take that again, by both parties, the employer can pay salary in lieu of the notice. How can let me go to the next one. Oh, I keep skipping it. I don't know if you can say, how can the employee, sorry, I don't know why I keep jumping to the next.
I mean, from the first part of the question, I can actually take the second part. So,
okay, how can the employee avoid staying for the 2 weeks notice? How can he avoid staying for the?
Yeah, it's by paying salary in lieu of notice, because those rights are actually mutual. So the employer can actually pay you off and say go off, and you can then say, hold on, I'm taking my notice, I'm giving notice, I'm handing in immediately, and so I pay my salary in lieu of notice for 2 weeks. So it's a mutual right for both parties.
Mutual.
So it's not restricted to just the employer. The employee can say, hold on, I want to leave immediately, so I'll pay you for the 2 weeks.
Okay, there's another one there.
An additional point to note. The requirement of paying in lieu of notice is one that must be met. You cannot, for instance, say, I will pay you. You cannot say, I will deduct it from my, because employees do that, or deduct my 1 month salary from my entitlement. That's not meeting the requirement of the law. When the law says pay, in fact, the language of the law is that it must be contemporaneous. You must pay. Now, it's a whole literature in itself where an employee decides, I want to leave immediately and pays. The next question is whether he's even entitled to anything beyond that. Because when you leave immediately, the law is that you are not entitled to be given or paid your benefits. Of course, there are two decisions I made. One, representing the general one. The second one explained the ramifications of what the benefits are. And I held that you are only entitled to earned monetary benefits. But for other benefits, which are mostly non-monetary, you cease to be entitled to them for leaving immediately. I made the point much earlier when I did my presentation that an employer cannot stop you from going, even if you are being investigated. A lot of people have asked questions, but it means the man is going. I said, no, he's actually putting himself in difficulty. Because if you are being investigated and you leave, the investigation stops. But you may need a reference tomorrow. And if you file for a reference and the man says, well, the man left when we were investigating him and we couldn't do anything, that is as much damaging as saying you were guilty. So that in itself presents its own problem. So even for the sake of the employee, you are required to weigh the option. Is it better for me to stay and clear myself before going, or I go immediately and risk this kind of adverse comment tomorrow? That's the choice you have to make.
My Lord, I would like to come back on, and I mean, there was an interesting point that came out of that elucidation. Beautiful one, my Lord, and which is that, and again, it goes back to that issue of conflicting position at times. I'm aware that there's a stretch of decision or thinking that the investigation of the investigatory process or disciplinary process will terminate when he resigns. There are one or two decisions that seem to suggest that it may continue. And I think my Lord alluded to that will terminate. My Lord, the position, what exactly?
How will it continue? Now, the decision I made, example, there's a court of appeal decision that said a staff suspended for disciplinary action,
yes, my Lord,
cannot resign,
yes, my Lord,
until that disciplinary process is concluded. But I said that decision did not factor in International Convention on Forced Labor, because the ILO says even if you are being investigated, the moment you are told not to go, each work you do after that is forced labor. So marry that with section 34 of the Constitution. And I said that Court of Appeal decision, because it did not factor this International Labour Organization Convention on Forced Labor, it did not factor section 34 of the Constitution, and did not factor the relevant provision of the Labour Act dealing with forced labor. I distinguish it from the one before me, because now I had to apply this. And I did the application, I still held the actions of the employer as null and void, unfair labor practice, to insist that the man must stay and answer to the disciplinary inquiry. And then, of course, because there are authorities that say, once you submit to the authority that you receive, I urge you to read section 306 of the Constitution as it relates to constitutional office holders. Once you tender resignation letter to the authority authorized to receive the letter, your resignation takes effect at that material time. That's the constitutional provision for office holders, constitutional office holders. Now, the same principle applies for normal master and servant. That's the point I'm making. Once you tender resignation, howsoever or whatever is the thing, you are deemed to have resigned. And if you go by Supreme Court decisions that say, once you go, any other thing undertaken is like an employer who decides to say, okay, your services are hereby terminated. Then he goes after 1 month, he says, no, we just found out that you stole our money. We have converted that termination to dismissal. The law is that after the termination, there is nothing to dismiss, because you are no longer in employment. And once you are no longer in employment, you cannot dismiss.
Amazing. Falabi, you think we have to draw the curtain, right?
Yes, thank you. Well, not without asking my Lord one final one. Still drawing from what my Lord just said. And
can't have enough, can you?
And I think, we can't have enough. We cannot have enough. And it's an area that we continue to engage. And interestingly, and happily too, and the jurisprudence keeps evolving and emerging areas, and for the benefit of employer alike. My Lord, there's an interesting one around that area. When you terminate, you cannot subsequently bring another layer of disengagement in process. So, and I'll relate to what happens in practice. Oftentimes, and the need for the thinking of the court to perhaps accommodate such a situation. Before now, an employer who perhaps wants to secure or enhance the prospects of an employee from getting further engagement or being employed, walks up to him, is not satisfied with his position at work, or the way he carries on his activity, his work, says that I'll give an opportunity to resign as opposed to outright termination or sack. Like I said, it's been suggested to inevitably help him to be able to go seek engagements for the future prospect without him having to explain the way that was terminated. And I think it appears that it's fair enough. The courts seems to be saying that that may, depending on the context of the fact how it plays out, to be summary, to be constructive dismissal. Yeah.
Let's assume the man is being investigated.
Yes, my Lord. Okay, my Lord. Apologies, my Lord. I just said one, and there's a related one to that. Now, recently I've had to look into a situation where, in this particular sector, there was a need to issue redundancy for non-unionized staff. of a big organization. And of course, they follow through the process as itemized in the handbook. And then some of them come back, some of the workers come back that, we've been with you for God knows how long. It's not fair that we know that, yes, this is inevitably on account of surplus labor, and then we are no longer required. Our service is no longer required. But consider that we worked with you for 13 years, 15 years. Where do you want to start from? We want to get an opportunity of still being engaged within this sector. And it will not look nice to go seek for employment and telling the prospective employer that you were declared redundant. I mean, you're almost not going to get the employment. Can you allow us to put in a letter of resignation? So this employer comes that, in the light of this new labor law context and all of that, I've determined the relationship. But human feelings, I mean, let's put a human face to this. They've come back to this. Can I give them this? Can I allow them to give and to put in letter of resignation? How do you marry that with what you've advised me that, the new labor context is, you must, if there's a need for reference letter, you must state the position accurately. So those are some of the things that in practice you definitely run into when decision seems to be, within that narrow prism that in that wise, it may be either constructive dismissal in relation to the first scenario given, or that it is not possible to have two methods or two written documents by which an employment is said to be brought to an end. It may be read to be unfair labor practice.
So many issues are actually brought up here.
Yes, ma'am.
I'm investigating you. And I said, look, we don't want to go the hog. Tender your resignation and go. And I allow you, you tender resignation, you go. Then tomorrow you turn around and say, no, he compelled me to go, and so on. Like I said, the facts and the circumstances will determine how it will be treated. There's no way in such a situation you will come back and be talking about constructive dismissal, because constructive dismissal presupposes no fault on your part. And the fact that you tendered resignation to avoid investigation, you are the one who talked about consideration a while ago. That in itself supplies the reason for which you were given the option to resign. So you can't come back to court and do that. The other scenario relates to reference, if I get the question very right.
Yes, reference.
Now, you are declared redundant and asked to go. By the way, redundancy is not something bad. It's not termination. So the question of coming back and saying, please allow me to resign, is immaterial, because it doesn't work. At the point of redundancy, there is no work continuing for which you will be allowed to terminate if the rules are to be applied strictly. But the one that seems to be an issue is you are dismissed. You came back, begged, and okay, we'll convert it to termination. Or we will withdraw it and ask you to resign. Well, if they collect the letter and tear it, of course, there's no evidence tomorrow. But if that letter stays in the file, and then you are allowed to tender resignation, and you tender resignation, and it is in the file, and both come to a court of law, the issue is, when were you dismissed? I was dismissed yesterday. You tendered termination today. Of course, at the point you were dismissed, there was nothing to terminate as at today. But for the sake of argument, let's take it to its logical end. Now, you were asked to terminate, to tender resignation, which you did today. And the question will be, why? For what reason? Okay, for the sake that I have worked harmoniously with you for how many years?
Yes.
Is that sufficient consideration to upturn this? The answer is certainly no. Did you pay money to be allowed to Did you enter into a new contract? Don't forget, even judgments can be compromised. Even judgments can be compromised. There's nothing that says if you have a judgment to be paid 10 naira, you cannot go and enter agreement and say, look, my friend, collect 5 naira as total settlement.
Absolutely.
So let's assume there was something that came up and there was an agreement. Then the issue is not so much about that employment, it's about this agreement. How you are going to prove it is, of course, dependent. Because if it is oral, the question is whether such an agreement can be oral. There are agreements that cannot be oral. It has to be in writing.
Writing.
So there is quite a number of things that will come up. There is something I want to say last before you close. Yes. I saw one of the questions somebody asked the relationship between Section 12 of our Act relative to the Court of Appeal case of SEC versus Uboboso. For those who may not know, in SEC versus Uboboso, the issue was whether NIC refusing to accept certification for public documents.
Yes.
Meant under Section 12 was correct. The public documents were presented in evidence, but they were not certified. The argument was raised that they should not be admitted. The NIC judge said, on the grounds of Section 12, I'm entitled to, for the interest of justice, I can refuse to apply the Evidence Act. So the documents were used, admitted and used as such without certification. When the matter got to the Court of Appeal, the main ground of appeal was that uncertified public documents were admitted when they shouldn't. So in dealing with that question, the Court of Appeal decided that Section 12 of the NIC Act comes earlier because NIC Act is 2006 and the Evidence Act is 2011. Under Section 256 of the Evidence Act, the Evidence Act applies to all courts except those exempted. And that NIC is one of such courts for which the Evidence Act applies. And on that ground, it was held that NIC was wrong on the grounds of Section 12. First, it was held that Section 12 cannot withstand Section 256 of the Evidence Act. And because of that, the admission of public documents that were not certified was wrong. So those ones were declared inadmissible. The moment they were declared inadmissible, it meant that there was no evidence to sustain the case. So the case of the employee was lost, and consequently, the appeal succeeded. Now, the question is this. The first question is jurisprudential. Can one statute of the National Assembly to be said to be incompatible with another statute? Here you say Section 12 of the NIC Act. The NIC Act is a National Assembly Act. The Evidence Act is National Assembly Act. Can you say the National Industrial Court Act is inconsistent with the Evidence Act? Both of them are acts of coordinate, to use our language, coordinate status, coordinate jurisdiction. You determine the validity of acts only when you relate it to the Constitution. You don't determine validity of one act relative to another act. Howsoever the conflicting provision, you must try to harmonize them. The worst case scenario, which I think is what they imported here, is that the latter in time supersedes the earlier. Now, even taking that on face value, Section 4 of the Interpretation Act was not considered. What does Section 4 say? It says when in an act there is reference to another act, and that act referred to is repealed, and a new one replaces it. Reference in this act to that repeal act must be read to be reference to the new act that replaced it. So when the NIC Act Section 12 referred to the Evidence Act, it must be read to also refer to the new Evidence Act of 2011, even when the old one was repealed. In any event, Section 12 of the Evidence Act did not say of NIC Act did not say Evidence Act 1990 or 2004. It simply said Evidence Act. those of you who are used to, laws of drafting, in legislation, once you refer to an act, you put the number of the act and the year it was made. If you go to the NIC Act, no such thing was done. It merely said Evidence Act. So, thirdly, there is the argument, if you look at Section 1 of the Evidence Act itself, it talks about admissibility and says, nothing in this law will stop the application of another law that deals with issues of admissibility. Now, like I like to tell students and people, in law as in logic, the converse of a proposition commands the same respect as the proposition itself. Now, if you have a provision in the Evidence Act that says another act dealing with admissibility can apply, does it not suggest that a law which deals with inadmissibility will equally apply? Then fourthly, I think there's a provision again in the Evidence Act, I think either Section 3 or so, that talks about nothing stops other laws on evidence applying. And I asked, if Section 12 of the Evidence Act, of the NIC Act says, in circumstances like this, rules of evidence can be dispensed with, is that not a rule of evidence for which the same Evidence Act acknowledges that it can apply? So, chiefly on the fact of Section 4 of the Interpretation Act not referred to, if I use the technical language, I would say that Court of Appeal decision was decided per incuriam, because it was decided without reference to an existing law, as at the time it was decided. But of course, as a judge of a lower court, I'm not going to use that word. I can only say I'm distinguishing that this was not considered in this case, and consequently, I cannot apply that particular decision. In fact, I had cause
which my lord did in Nebuta. Which my lord did in Nebuta's case.
Privately, I have been discussing with even the Court of Appeal justice who decided with Boboso. And I think he has seen our point. Let me put it that way.
Yes.
He has seen our point that no. Even apart from reference to Interpretation Act, I've explained to him that, look, there are a lot of things that don't just, I gave some few examples. The ordinary ID card of an employee is not even his own. How do you expect him to come and prove the fact of employment? Conditions of service, some establishment will write on the condition of service, these conditions of service are the property of this company. And the man is making a claim based on the conditions of service, and he does not have access to it. And modern day systems have now done evolved system where most of these documents, you find them online. And the day they sack you, you can't even access it. So all of these things weigh to say, look, when you come to employment law, employment adjudication of employment disputes and so on, whether we like it or not, these rules of evidence must be relaxed. But my chief quarrel with Uboboso is the fact that it was decided without reference to Section 4 of the Interpretation Act.
My lord actually took time to analyze all of this in distinguishing Uboboso in the case of Buta, I think, which was decided almost like a year apart from Uboboso. Your lordship had taken time to, and I thought that by now, because that was 2017 thereabouts, that maybe it would, the Court of Appeal would have had another opportunity to revisit that position. Unfortunately, it appears Uboboso is still the position, my lord. I mean, they will go by
Uboboso no opportunity has arisen to apply or even to consider it. Even when Obute went to Court of Appeal, I was overruled on the merit of the case, but they didn't say
it was much. Yes.
It wasn't said much about the
evidence here.
Oboboso, yeah.
Yes.
It wasn't so much about the evidence. I think it was so much about fair hearing.
Yes, madam.
Fantastic.
On that note, my lord is the spirit of wisdom. Somebody just said that. I'll hand over back to Tobira. Thank you very much, my lord. Thank you, sir.
You're welcome.
Olabi, thank you very much. Yes. I must say that this has been, I don't know whether to say for the price of one. I'm saying for I'll give my lord two and give you say one each, you know, but it's been amazing. And I think Olabi, you can turn your camera back on because I need to show you.
That's all right.
It's not my. I was only called in to come and read the questions.
No, don't worry. Don't worry. We're waiting for you. I mean, the thing is, just thinking about it from a structural perspective, right? I think there's a dimension that's coming with my Lord being part of this session throughout. And I know it's quite demanding to ask anything of the time of a judge, because we know we don't have enough judges in Nigeria. And our judges are inundated with, I mean, it's almost unbelievable how they manage to do the work that they do under the circumstances that they do in. However, I think that my Lord being here has brought a new dimension to the conversation, because I think we were able to nail certain questions down to finality. So I don't know what magic you, Ose, and the team will do, and I'm not suggesting that you bring back my Lord, but perhaps other justices of that court might be, you know, who could be brought in sessions would also help to bring a perspective from the bench to the conversations that we have. I think this has been a comprehensive and complete conversation, not least because we have my Lord, we had him throughout. So Ose, thank you very much for your presentation. Concise, brief, direct to the point. My Lord, absolutely grateful for you to have stayed on. And I mean, again, scholarship at its best. I knew you couldn't miss Ose's presentation for anything, but thank you very much. Falabi,
You're welcome.
thank you. Falabi, great stuff for your end. I think we
all
just
I would just advise.
Question manager.
Yes, no, all I would just advise is, I mean, looking towards my Lord for the continuing legal education. You should also still consider bringing my Lord at a point. Of course, you need to go and ask my Lord convenience and all of that. So come and treat consumer protection, consumer protection tax. My Lord,
don't bother yourself. They know where to meet. Don't bother yourself. Just leave it.
We know where we meet. Don't worry about that. But well taken.
Yes.
There's so much. You see,
so rich knowledge. Yes.
No, the truth of it is that giving back is a big thing, and
correct.
Every day we seem to be losing the best of us or not having them around available. So when we have someone who has a lot to offer and willing to give it, we must behave like those who climb the Iroko tree. We will try to pluck it off, which is what we're trying to do today. So my Lord knows that I will very soon be approaching him to have even a much more robust conversation about his experience today and what we need to do, and perhaps his own dimension to it, considering his academic background. But thank you very much. Thank you, my Lord. Delegates, thank you. Without you guys, we wouldn't be here. So thank you. Let's keep promoting these ideals of capacity building, capacity development, because I mean, just sitting down with my Lord, it is not, I think the main benefit is not just what you've heard. It is also everything around the presentation, the style, the panache, the conduct, and all of that. So thank you very much. And God bless you all. And hopefully we'll see you soon. I think the next session is on what day, I'll say? Is it Monday?
Tuesday.
Yeah. Monday.
It's on Monday. On Monday.
It's on Monday. Okay. So see you guys on Monday for those who can make it. God bless you all. And thank you very much.
Thank you very much.
Thank you.
Thank you, Milord.
Thank you very much. Yes.
Thank you all.
Thank you. Great, sir. Yes.
We see together, Milord. We see where they see. Yeah.
No problem. So nice being here today. Yes. Thank you so much. Yeah.